and spell your name.
Jennifer Bogan, and it's JenniferBogan.
Back in 2010, what was your address?
494 South Main Extended in Collierville.
Collierville, Tennessee.
Yes, correct.
Drawing your attention to the month of July, is there a particular date in July that sticks out in your mind each year?
The 18th
The 18th?
of July.
And I know you're soft-spoken, but we got a court report, so you got to speak up where they can hear you as well. But July 18th, 2010, was anything going on particularly that weekend?
Yes, I had a cookout that weekend.
All right. What day or days?
Saturday and that Sunday.
All right. And that Saturday would have been July 17th?
Correct.
And how did you end up having 2 days of cooking out?
That Saturday, we had the cookout started, and then that Sunday, since I had leftover food, I invited my church members over that Sunday.
What church was that?
Mount Olive number 1.
And do you know of Billy Ray Turner?
I do.
How do you know Mr. Turner?
He's a family friend and also a church member.
And how long have you known him?
At least about 20 years, I would say.
And on that particular day, or that weekend, did he come to your home as a visitor?
He did.
Which day?
On Sunday.
That would have been July 18th?
Yes, correct.
Do you remember around what time he would have come to your home?
I would say early afternoon after church.
Maybe 2 or 3 o'clock?
Correct.
Your Honor, may I approach
Yes, sir.
Mr. Hagman, provide the copy? I'm going to ask you to identify what you see in those photos, and then I'm going to pass the photographs to the
Sorry
judge.
guys, I was watching Formula One qualified this morning, and I forgot about this. I've been looking forward to this all year, so my bad.
Never see those, did you?
Did we take a look at it?
No, well, I
Yes, sir.
didn't know if.
I have a request.
Okay.
That we'll deal with in a few minutes, but it's not anything relative to anything else that's going on right now. It's a scheduled request.
Yes, sir.
Yes, sir. You may proceed.
All right. On the first photo, what is that on that first page?
It is a photo of my backyard with some of my church members sitting around at some tables I had set up in my backyard.
I asked you about a person a few moments ago, Mr.
Uh-huh.
Billy Turner. Do you see him?
Yes,
And where is he depicted on that photograph?
he's sitting at one of the tables.
And what does he have on?
Red and white stripy shirt.
All right, and can you turn the page to the next page, please? What's depicted in photograph number 2?
Some of the members that was at the party sitting at a table on the outside up under the carport at nighttime
All right.
playing cards.
Now, in that photograph, is Mr. Turner present during that photograph?
He is not.
Now, is he still in your home from your memory at the time that photograph would have been taken?
I would believe so.
And I'm gonna ask you about the next photograph, please. What's depicted in that photograph?
Myself holding up one of my birthday gifts, and Mr. Turner is in the background of the picture.
And is that later in the evening also?
Yes, I opened my gifts toward the evening of the day.
I'd ask that those be passed to the judge.
Ms. Schofield, would Mr. Hagerman, any objections to this offer of proof?
No objection, Judge.
Exhibit 104-104. Photograph described by Ms. Bogan as a photograph of church members at a table during this
Trying to
cookout
go to church before I shoot, folks. Hey,
with Mr. Turner
gotta
pictured
clean
in a
that-
red
gotta
and
clean that
white
slate off
shirt.
before you add
Exhibit
more to it.
104, church members at a table. Exhibit 105,
I'm not gonna lie, if this is the totality of their case.
Photograph
this is not
described by
looking
Ms.
good
Bogan
for
as
the defense.
showing-
Like, oh, I wasn't there, and I doubt there's any timestamps or ways to really
church
verify
members
it
at
on
a
that
card
camera, so,
table.
Yeah, this ain't good.
Exhibit 105, and for the record, Ms. Bogan indicated Mr. Turner is not in 106 photographs describing Ms. Bogan as a picture of her holding one of her birthday gifts, with Mr. Turner pictured in this photo, Exhibit 106, Ms. Bogan holding a birthday gift.
Commissioner Butler, Your Honor.
Yes, sir, you may.
I'll pass it down. Thank you. That's right. Now, in those photographs, oh, I'm sorry. I thought-
I would love you to keep talking.
I apologize.
You're gonna lose the interest and attention of the jury if they're looking at pictures you talking at the same
Yeah,
time.
yes, sir, Your Honor.
Not a problem. You need anything, Ms. Bogan? You need a glass of water? Okay, you're all right.
Are we still frozen, or what's the deal here? Oh, no, we're not frozen. I didn't hear what we took a break for there, so.
Ms. Perry, you may proceed. Yes, sir.
During that afternoon and evening, approximate how many people were in your home?
I would say at least 20 maybe.
And they were engaging in different activities in the home and
Yes.
outside?
And inside and outside, yes.
Do you remember if Billy was engaging with other people in the home?
Yes, he was engaging with the guests there. He was playing basketball outside with some of the teenage boys and my sons.
And during that evening, there was one of the photographs that he's not actually depicted, but there are people that are sitting around a table. Where's that table area?
It's outside up under the carport.
And do you remember approximately when Billy would have left your home?
I would say around 10 or a little bit after 10 because I started cleaning up then.
Do you remember if he helped with the cleanup procedure?
He did.
Of the guests that were there, what was his, I guess, order of leaving? Was he one of the last to leave?
Yes.
And you said he helped clean up, what all was how was he helping you clean up?
When I started to move around and shut down, he was just known to start helping clean up with the tables and stuff, like some of the tables that I had there.
And during the course of that day or evening, did he sing himself like you normally know him?
Yes.
All right. And can you tell us what you normally know when you see him?
Very festive, joking, interacting a lot with the children. He's kind of like a mentor to some of the little teenage boys that was there. Just being himself.
Was there anything odd or rushed about him or nervous acting about him at all?
No.
And you said that he was one of the last to leave, and he did help you clean up everything.
He did. Mhm.
Your Honor, may I approach?
Yes, sir.
few moments ago, I asked you about your address. What was the address back then?
494 South Main Extended.
All right, and in that, I just handed you a map. Do you see where your address would be on that map?
Yes. Over here.
Is that where the dot is?
Yes.
And you see a line drawn to another address.
Correct.
Can you read the address that that line is drawn to?
4530 Whisper Woods Drive in Collierville, Tennessee.
All right. Are you familiar with that address?
I am.
All right, and do you know a Sherra Wright?
I do.
How do you know Sherra Wright?
She was also a member of my church.
Now, was she at your party during that evening that you remember?
She was not.
And you see the distance, does it mark a distance on there?
Yes.
What is the distance that it's saying between those two homes?
2.12 miles.
And give me this next. Yeah, I'd ask you that to be marked as the next exhibit, please.
Any objections, Mr. Tagerman?
This will field.
I think the last page may be blank.
Last page, no.
Yes, Gabby, hit that button, it's waiting for you.
So these two you want admitted as a joint exhibit, Mr. Perry?
Yes, sir.
Yes, sir. Ms. Bogan, when Mr. Perry asked you about a circle and you pointed to something, you showed it to me, but it may be difficult for the jury to get an appreciation for what that was.
Okay.
So I'll give you a red marker,
Okay.
and if you could put a red marker around the circle that you identified as your house, that would probably help the jury. Okay. Yes, sir.
Thank you.
It's fine, that's fine, it's perfect. Because I could barely see it, and if we showed it to the jury, they would not be able to see it. Okay. Yes, sir, this is exhibit number 107.
107. Billy Ray's such a nice boy, he always had Jesus in his sights. Delivering the
It's a Google
magnum
map
of the Holy
identified
Gospel.
by Ms. Bogan as showing the location of where her house was on 494 South Main Extended in Collierville in relation to an address of 4530 Woods. "4530 Whisper Woods Drive in Collierville, Tennessee, a distance that Ms. Bogan says is about 2.12 miles distance between her house and the house in Whisper Woods. A Google map, exhibit number 107. You want to have that handed to the jury, Mr. Perry?
Yes, Your Honor.
Deputy Smith?
Turn the mic up. Just like a constant battle with this thing. Can you guys hear me now? Yes, no, maybe so? So I'm not sure, we're waiting right now, but yeah. Billy Ray just had Jesus in his sights all the time and delivered that gospel like a magnum revolver. Such a good boy. I have the feeling this is not going as planned. I really hope this is the totality of his defense. I turned away. Is this just an AV issue right now? What's the deal? Huh. Yeah, hey Teddy, long time no see. Hey everybody. Lori Beth, I hope you're feeling better today. I know the chat's a little quiet. We don't have Matthew here to make a deliver smart ass remarks, so I know it's a little quiet today, but we'll survive. We'll pull through. We will persevere.
Ms. Perry, you may proceed.
Sir, just a few other questions. You said that during that evening that he was cleaning at the conclusion of the party, and based on your memory, you think he was one of the last or the last visitor to leave.
Mm-hmm.
And in the home, is that anything that would have been out of the ordinary for him to do to try to help?
No, he was always helping. That's just his character, to help.
I don't have anything further.
Murders.
Mr. Hagerman, you may proceed.
I just have a couple questions.
Okay.
Ms. Bogan, I've met your dad before. He had us to his house.
Oh, okay.
And he's a nice man. And just a couple questions. You said that Mr. Turner would have left around 10-ish? Is that right? Okay, so with regard to your personal knowledge, what you actually know from your personal knowledge, do you know where Mr. Turner was at midnight?
I do not.
Any idea where he was 12 minutes after midnight?
I do.
Yeah, that's gonna kill
Any
him.
idea where he went after he left your house?
I do not.
From your personal knowledge, do you know about his relationship with Sherra Wright?
I do not.
At the time that these events happened, way back in 2010, did you know that Billy had a car and a truck?
Yes.
And did you know that Billy had taken a trip to Atlanta?
No.
I've never heard questions.
Hagerman, thank you. Ms. Perry, any additional questions?
Would it have been odd for Billy to loan his car to anybody?
He was always doing whatever he can to help anyone.
I don't have anything further, Your Honor.
Ms. Hagerman. Ms. Bogan, thank you for being in court on Saturday morning. I'm going to excuse you for any additional testimony in this case, ma'am. You can stay and watch the rest of the trial if you want to, if you're able to do so, but you cannot discuss what you testified in court with anyone or allow anyone to talk to you about other witnesses' testimony.
Okay.
Thank you. Step down and watch your step, please,
All
ma'am.
right, thank you.
Thank you, ma'am. Counsel, approach, please. Ladies and gentlemen, I got a question from one of your members while Ms. Bogan was testifying. I told you in those preliminary instructions that you might submit a question to the court, and I can't ask it, can't have a witness answer it. If that witness probably would not be able to answer that question, I'm not going to submit it to the witness. So whatever the question was, don't discuss it. With your other jury members, don't take it into consideration for any reason at all. If that question that was submitted by a member of the jury has been answered by other proof in the case, you may consider the question and the answer. But if not, please disregard the question and don't discuss the question with other members of the jury. Mr. Perry and Mr. Thomas, do you have any additional proof?
No, Your Honor. It's rest.
State, Mr. Hagram, Ms. Schofield, do you have any rebuttal proof?
We have no rebuttal proof, Your Honor.
Ladies and gentlemen, you heard all of the proof that you will in fact hear in this case. It's 11:30, and what I need to do next, I need to talk to the lawyers about the jury charge. I told you on Monday that it would be about 30 pages long. It's about 30 pages long. I need to talk to the lawyers about things that they might want included, things that they might not want to have excluded in the charge, rather. And we'll conduct that charge conference. It has to be done outside of your presence. We'll discuss another legal issue or two with the attorneys. And I'm going to make 22 or 23 copies of this charge. And this afternoon, I'm going to read this law to you. We're going to present the law to you. We'll talk about other scheduling issues once the charge is being presented. And I got a note from one of your members that indicates, is there any way that we can resume on Monday after today? Sunday is a religious day for me, if it is possible. And what I told you on Monday, that we will work on Sundays only if all the jurors say just coffee, that's fine with me. But if somebody tells me the judge is religious, they don't really have a religious objection on working on Sunday, we would not hold court on Sunday. We would charge this case today. We'll reach all the law that could possibly apply in this case. And the lawyers will have 3 different arguments they can probably present to you. State of Tennessee will present a closing argument. Mr. Turner's attorney, either Mr. Thomas or Mr. Perry, will present an argument if they choose to do so. And if they do choose to do so, the state can present a rebuttal argument. As I told you, I cannot limit lawyers' arguments in Tennessee. The law says, Judge Coffey, you have to give lawyers a reasonable time, adequate time rather, but not an excessive time. Now, of course, it never really defined what is adequate and what is excessive. So those arguments might take an hour and a half. They might take 3 hours. Collectively, might take longer than that. So it would be imprudent to argue the case and then have you start deliberating today, because I don't want you to think that we have to rush through a decision and we want to get out of here on Saturday and we're just going to reach a decision on this case so we can get this over with. And what I told you on Monday and what I told you on the 4th of March, when I saw you at the jury assembly room of 157 Poplar on March 4th, that this case probably lasts somewhere between 7 and 10 days. The lawyers have been really efficient. This is day 6, and all the proof has been heard. You hear all the law, so you're actually way ahead of schedule, because I thought we would be here until Wednesday or maybe Thursday or Friday next week. You will hear this case. You'll be hearing arguments on this case, and this case will be in your possession. To make a decision whether or not Mr. Turner is guilty or not guilty, that will be in your possession on Monday. And we are at least 2 or 3 days ahead of schedule, and I will give deference to your member or members who say, Judge Coffey, I really don't want to work on Sunday. Can we resume this on Monday? And I will give deference to the will of the jury. And if one person tells me that, it is a 100% democracy, and we will charge this case today. As soon as I talk to the lawyers about what they want included or not, and we'll give you all the law in the case, and we'll start jury arguments at 10 o'clock on Monday morning. Have to qualify grand jury at 9 o'clock. We change grand juries every 3rd Monday on alternate months. So Monday morning at 9 o'clock, I will qualify 24 of your fellow citizens to serve on a grand jury for Tuesday and Thursday for the next 2 months. And at 10 o'clock, we'll start arguments on this case. You still cannot discuss the case with anyone or amongst yourselves, and we'll start reading this law to you in a few minutes. If your lunch gets here before we conclude this jury charge conference, don't have you eat lunch, and we'll start reading the charge to you after the lunch break. You can follow Deputy Smith,
Yes,
and I'll see you in a
Parallax,
few
stay
minutes, or
rested.
I'll see you in about 2 hours.
It's over.
Thank you all.
So, Teddy, you asked, is that bad if Hold on, where did you ask it? Does it send the wrong message if the defendant doesn't testify? No.
So I guess the discussion we had this morning.
It shouldn't.
Door to close, I'm sorry. And now for the record, the jury is out. The discussion that we had this morning about scheduling, I guess that question has been definitively, conclusively answered by the jury. And we'll read the question for the record as it is written.
Yeah, I guess we're going back to
quote,
usual,
is there
sadly."
any way that we can resume on Monday after today, exclamation point. Sunday is a religious day for me, period. If it is possible, period. So at least one of the jurors have told me in writing, which has never happened before, that Judge Crawford really don't want to work on Sunday. We would rather resume on Monday. And I would defer to the will of that jury, and we will charge this case, fully charge the case, and on Monday morning, we'll start arguments at 10 o'clock a.m. as indicated. I have to swear in the next March term of the grand jury for the next 2 months. And they'll still be here on Monday morning at 9, and we'll start jury arguments promptly at 10. Both sides having arrested and closed as proof. Ms. Perry, Ms. Thomas, do you have any additional motions on behalf of Mr. Turner?
Your Honor, I would just like to renew my motion for the verdict.
Mr. Hagerman?
Same response as before, Your Honor. Ask Your Honor to deny the motion.
And the court will incorporate the rulings that are made at the end of the state's proof. Both sides have arrested and closed. The court still is firmly of the opinion that this is a factual issue and a credibility issue
Okay,
that
so
should
they
be
just
resolved
did a
by this
motion
jury,
dismiss.
and the court will deny the motion for judgment of acquittal. What the court intends to charge in the case, and it's indicated I've been working on this charge since February 28, 2019. That's when I started drafting this charge, and I made some revisions as this week has gone on. We'll charge in count 1 of the indictment, the indicted charge of first-degree murder. And at the request of Mr. Turner, waiving any possible objections to the statute of limitations, the court will also charge second-degree murder as an included offense, facilitation of first-degree murder, facilitation of second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, and criminal negligent homicide. Would not charge facilitations of reckless and criminally negligent homicide because Tennessee law is that you cannot intend a reckless or negligent act, so facilitation would not be an included offense of
Is
those
this better, guys?
charges. Will charge conspiracy to
Can you
commit
hear me
first-degree murder in count 2 of the indictment, facilitation of conspiracy to commit first-degree murder. Count 3, criminal attempt first-degree murder. The included offenses of facilitation of criminal attempt first-degree murder, criminal attempt second-degree murder, facilitation of criminal attempt second-degree murder, criminal attempt voluntary manslaughter, and facilitation of criminal attempt voluntary manslaughter. Would not charge attempted reckless homicide or attempted criminally negligent homicide because, again, Tennessee law says you cannot intend to commit reckless or negligent acts. So those are the court's intentions to charge the greater offenses, charge offenses, and the included offenses. Will also charge criminal responsibility for the conduct of another.
Jesus Christ, how many
As
charges this
indicated
guy gonna
earlier,
face?
those included offenses will charge criminal attempt for the conduct of another, telling the jury that a defendant is criminally responsible for an offense may be found guilty not only of that offense, but also for any other offense or offenses committed by another. If you find beyond a reasonable doubt that the other offenses or offenses committed were natural and probable consequences of the original offense, defining for the jury what criminal responsibility is, and responsible for an offense committed by the conduct of another if acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, the defendant
Hi, Shannon.
solicits, directs, aids, or attempts to aid another person to commit the crime. We'll also tell the jury that to find the defendant guilty of criminal responsibility for the acts of another, it is not necessary that you find the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Would charge facilitation of a felony offense as indicated earlier. Will give the jury a long charge on identity. Those other charges that we're required by law to charge: presumption of innocence, reasonable doubt, burden of proof, direct and circumstantial evidence, impeachment of a witness, prior consistent statements, a lone charge on witness credibility. We'll also charge the witness on accomplice and what accomplice testimony is, and what or who might be an accomplice in this case.
No, Shannon, this started a while ago, but I was a little late. But we're done. The case is all the way done.
For the record, accomplice, our court, Supreme Court, Court of Criminal Appeals has defined an accomplice as someone who knowingly, voluntarily, and with common
Song of the
intent
South critter.
participate with the principal
Road dog,
offender in the
Jesus.
commission of a crime alleged in the charge and indictment. Among other cases, State versus Griffiths, Griffis, 964 Southwest 2nd, page 877, 1997 Court of Criminal Appeals opinion. And the court has to make that threshold decision originally. And the question, among other things, is whether or not the witness status as an accomplice is answered by determining whether that person could have been indicted for the charged offense. Tennessee case law would also indicate that if the facts about the witness participation in the crime are clear and undisputed, the trial court should determine as a matter of law whether the witness was an accomplice. However, if the facts are disputed or subject to different inferences, the jury should determine as a matter of fact whether the witness was an accomplice to
That's
the
talking about
commission
Jimmy Martin.
of these alleged offenses.
Yes.
Among other things, the State versus Robinson, ROBINSON, 239 Southwest 3rd, page 211, 2006 Court of Criminal Appeals opinion. And because of that, the court will in fact charge the jury that Jimmy Martin is in fact an accomplice in the alleged offenses of criminal attempt, first-degree murder, and
Makes 100%
conspiracy
sense.
to commit first-degree murder, and that a jury cannot convict Mr. Billy Turner on the uncorroborated testimony of Jimmy Martin for those offenses of criminal attempt, first-degree murder, and conspiracy to commit first-degree murder, and that the accomplice testimony, in fact, must be corroborated, and accomplice testimony cannot be corroborated by another accomplice's testimony. We'll also charge the jury that it is a question for the jury to determine whether the witness, Jimmy Martin, was in fact an accomplice in the alleged offense of first-degree murder. And if the jury finds that he was in fact an accomplice, then the defendant cannot be convicted upon the uncorroborated testimony of Jimmy Martin. And if they find that he was in fact not an accomplice to the first-degree murder, then the jury would judge the weight to be given to his testimony just as it would any other witness in a case. And again, the court is the gatekeeper of that decision on finding that based on the record, based on the proof that is before the jury, that Jimmy Martin is in fact an accomplice to attempted first-degree murder and conspiracy to commit first-degree murder. Do not find, as a matter of law, that he is in fact an accomplice to first-degree murder because his role in that offense or the commission of the offense is in fact not clear. It is in fact subject to different interpretations. It's a factual issue as to whether or not the jury wants to believe Mr. Martin or whether they want to believe that he was in fact a party to all of this. And that is a question for the jury to make in the case, and I would give that question to the jury and have the jury determine whether or not he is in fact an accomplice. I would not charge Claudia Robinson as an accomplice to any of these indicted charges. There is absolutely nothing on the record that would indicate that Ms. Robinson knowingly, voluntarily, and with common intent participated with a principal offender in the commission of these crimes that are alleged in the indictment. Ms. Robinson indicated she was present at 2 meetings in which Mr. Martin, Mr. Turner, and Ms. Wright had discussions about killing Lorenzen Wright because Sherra Wright believed that Lorenzen Wright was going to have her killed. Ms. Robinson indicated that she thought that Ms. Robinson was, Ms. Sherra Wright, rather, her first cousin, was not being serious, that she told her that she did not believe Lorenzen Wright would try to have her killed. They had children, thought she was not being serious about that at all, and that she basically blew it off and left. Even after Ms. Wright allegedly made statements that it's either him or me, and he has to be gone. On the second conversation, Ms. Robinson indicated she was present when this conversation again took up amongst those 3 people about having Lorenzen Wright killed. And her response was not an exact quote because I'm not transcribing the record, but what I wrote down is that, quote, "I can't believe he has a hit out on me. He wants me gone." Allegedly is what Sherra Wright said. And Ms. Robinson said she again tried to discourage her from making those statements, did not believe that it was true, and at some point said that Mr. Billy Turner indicated whether or not Sherra Wright thought she was going to be a problem. And Sherra Wright responded allegedly, no, she can be offed too. And when she heard that she was pregnant with her first child and she decided that she was leaving, decided not to have any more contact or communications with Sherra Wright, did not report it to anybody because she feared for her safety and the safety of her unborn child, and did not report it because she said, especially when she found out that Mr. Lorenzen Wright had been killed, that if this woman just had her husband, ex-husband, a father
Guys, we'll
of
catch up in a
many
second. I
of
wanna
her
listen to the
children
judge.
killed,
Sorry.
and she's already threatened to have me offed also, what in the world do you think she would do to me? So there's absolutely nothing on the record that would show that Ms. Robinson knowingly, voluntarily, or with any common intent participated with any of these 3 people in the planning, the execution of any overt steps that would indicate Ms. Robinson is in fact a accomplice to any of the actions that were taken, if any, by Mr. Billy Turner, Sherra Wright, and Jimmy Martin. So I would not charge Ms. Claudia Robinson as an accomplice. Her testimony would be considered without any need for anyone to corroborate anything that Ms. Claudia Robinson may have testified to. We'll also charge the jury. Yes, sir. I will give you a chance to respond. Just telling what I intend to charge, and anything else that you want to object to, you are free to object. We'll charge evidence of other acts, indicating if the witness, they find the witness that's engaged in other acts who've been charged with other crimes, they can consider such prior acts only for the purposes of effect, if any, on the witness's credibility. We'll charge the jury on expert witness. We'll charge the jury on Mr. Turner's election not to testify. We'll also charge the jury on omissions against interest, any prior statements that may have been attributed to Mr. Turner, either through witnesses or statements that, oral statements that he gave to the police. We'll charge the jury on that. We'll also charge the jury on stipulations, charge on jury notes, charge on no outside communications, and a unanimous verdict page. Those are the first 24 pages of the charge. The last 5 or 6 pages relate only to what verdicts the jury can reach and how they go about recording that verdict. And I know you have an objection, Mr. Thomas. You may proceed with any objections or any recommendations that you want the court to consider charging.
I apologize for the interruption.
It's okay.
When you were speaking about Claudia Robinson, when she heard about her being a problem and she can be off, you said that Billy Turner said that when actually it was Jimmy Martin.
If I said that, I misspoke, and
Yes,
I apologize.
Yes, sir.
I apologize if I said that I misspoke. Those words were Ms. Sherra Wright's words, allegedly. So if I said Mr. Turner, that was a misspeak on my part, and I do apologize to you, Mr. Perry, and Mr. Turner. It is clearly something that Ms. Sherra Wright allegedly said as to why Claudia Robinson decided not to report it to anybody because of her cousin had allegedly just had her husband killed, ex-husband. She had no hesitation that Ms. Wright would have her killed also. So not words that Mr. Turner said, those are words attributed to Sherra Wright. If I said anything else differently, charge it to my head, not my heart. It was just misspoke on my part. Any objections to what has been proposed?
That's
Mr.
nice of the
Terry,
judge,
Mr. Thomas,
being
any recommendations?
honest
Is
about that.
anything that you might want included?
No, Your Honor.
I thought about charging alibi. Did not charge alibi, because the last witness who testified really did not present, Ms. Bogan did not present an alibi, for Ms. Turner.
That's
She
correct. It's
indicated
not an effective
that she last
alibi.
saw him about 10 o'clock at night. Sherra Wright's house is 2.12 miles from her house and has no idea where he was before midnight and after midnight, so it's really not an alibi. So I will not charge alibi for those reasons, because it's not been properly raised by the proof in the court's opinion. Mr. Hagerman?
The only question I have is on the criminal conspiracy charge.
Yes, sir.
Tennessee pattern jury instructions extend to 2 pages. I wanted to sort of see your charge and make sure we have the entirety of that included. The second page, conspiracy is a continuing course of conduct, which outlines some details of the charge I think are important.
I'm gonna go put this on speed blast. So I will try to read it so the court reporter can follow, because I'm told that I talk real fast sometimes. Any person who conspires to commit an offense is guilty of a crime.
I've been there myself,
For you to
Judge.
find the defendant guilty of criminal conspiracy, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant entered into an agreement. Basically, what those first 4 things that I would read is exactly what is contained in the preliminary jury instructions that I gave the jury. So those first 4 essential elements are exactly what the jury has already heard, and we'll follow that up with the term intent has been defined in the definition of intentionally in the first-degree murder instructions. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that they be completed is abandoned by the person and by those with whom the person conspired. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. And we'll also define for the jury what the elements of first-degree murder are, which have already been set out and explained in count 1 of the instructions. So that's what the court intends to charge. Is there anything else the state believes should be charged? Okay. Any other objections or recommendations from the state?
Yes, sir.
We'll print this charge and we'll provide it to the lawyers. And once it's been printed, hopefully we'll not have any further objections, because I don't want to print 25 more copies. And is jury's lunch here yet, Deputy Phillips? Should be here around 12.
Deputy has no idea.
We'll print the charges, allow the lawyers to look at it, and juror's lunch will be here at about 12. So that's I told the juror, we'll bring it back in the courtroom, or we'll send in about 2 hours, and we will start charging this case at 1. .30, because it's going to take me a while to copy 20 some odd charges. We'll start charging the case at 1:30, and once the charge is being completed, I would grant deference to at least 1 juror. It says, Judge Coffey, can we please start on Monday morning? And we'll argue the case at 10 o'clock on Monday morning. Anything else we need to do before we take this recess? We call the court into recess. The court will stand in recess until 1:30 p.m. and we'll start the jury charge at 1:30.
That's 2:30 p.m. Eastern time. Okay, those notes the judge took, those are the judge's notes just to keep track of things. Judges will routinely keep a list of notes, like they'll keep a track of all the exhibits. That way at the end, when they try to admit all the exhibits, they can be admitted. He'll keep notes of testimony. And why? That way if there's an objection in claiming that things were not factually argued one way or another, the judge could say, no, it's the court's recollection, this happened, this didn't happen, they said this, they said that. So that's normally what happens, and that's why the judge is doing it. Those don't get part of the record. That's just so the judge can keep track of stuff. Every state might be different, but at least that's my understanding, and at least here in Ohio, that's not something the court, an appeals court would ever see. I think, Teddy, you asked way back at the top. Yeah, guys, I am sorry. The Bahrain Grand Prix qualifying was this morning, and I've been looking forward to this for months. So, yeah, my phone kind of exploded and said, "Hey, it's on now." So, yeah, I apologize. I got delayed. So that's not really an excuse, and I need to work on that. But I apologize still. Um, so what did I want to say? Yeah, one of the jurors said Sunday is their religious day, so they don't want to do jury stuff tomorrow, which I think is weird because wouldn't that have already been discussed when he told them they were going to work through the weekend? But yeah, Night Watch, isn't it Saturday? Yes, it is. And hello, I don't know if I've seen you before. Thanks for stopping by. If you like it, like and subscribe. That'd be great. Um, I forget who it is that asked, isn't it bad that he didn't testify? Um, I mean, what's he going to testify to? Say I didn't do it? That's presumably what he would say. I didn't do this. And then he'd have to, and he'd have to explain away what Jimmy Martin said and what all the other evidence shows. Because that would come up on cross. So no, he shouldn't be doing that. No, him shutting up is probably the best case. Really, self-defense is like the only time you should be taking the stand. There's no incentive for him to do it in this situation. So Monday we'll be closing arguments. That will start at 10 o'clock Memphis time, 11 p.m. I'm sorry, 11 a.m. Eastern Standard Time. So I will have that running. They're going to do their closing arguments, and the jury's going to have it. Today they are going to finish up the jury instructions, charge the jury. By that means, read the jury instructions to them, and then yeah, we'll have a whole day of nothing. So, somebody asked, what is it? What is it with the barbecue thing? I don't know. At least they didn't eat him. We don't have to worry about that. Why is it that people? Here's one, Robin. Yeah. How many times have we seen people eat after they murder? That's what I don't understand. There's some psychological thoughts behind that. Some of it is people know that they might get sick, and you don't want to go try to kill somebody if you've got a full stomach. You might get sick. It's unnerving. There's some issues there. There's a lot of adrenaline afterwards. That can cause you to be hungry. So that's not uncommon at all. That's a very common thing. People will go out to will try to eat food after they've committed a crime like that. What else is going on here? Yeah, tomorrow's off, and then Monday we'll be closing arguments. Of course, I start back work Monday. Yeah. Oh, it's you, Sue. Okay, well, still like and subscribe. I'll take the like and sub. The wife's trial, I don't know if she's online at all. Yes, the undercover witness already went on. So Forum, I hope I answered your question. Yeah, the notes are gone. That's not part of the record. It's just so the judge can keep his stuff sorted out. What else we got going on here? Questions you guys asked. So even though this Western they go to church, well, Lori, it's not that necessarily this juror's going to go to church, but it's the idea that you don't work on the holy day. For her, the Sabbath is holy. She probably will read, whoever it is, they'll probably read their Bible, anything like that. But you just don't work on the holy day. So it's a common thing for Jews. They don't work Saturday. Well, for Christians, it's work Sunday. I mean, if you take it seriously, what's the point of charging the jury and then taking time off right away? Well, because the jury will understand all the rules and they get all the instructions. Now, when I've talked to jurors, they pretty much ignore the instructions and do what they want. So it doesn't matter you tell them now or you tell them later. But they may as well because they've got the opportunity. All right, bye, Pauline. Have a nice day. Am I a Ferrari fan? Okay. I'm not like a Tifosi, but yes, I do like Ferrari. I've always thought they've been pretty cool. Their cars look pretty sick this year. I think they look pretty gnarly. I am surprised they. Yeah, I mean they came out hard this year. I was a big Williams fan until George Russell left, so I don't really like Mercedes a lot. Um, I do like Valtteri Bottas a lot though, but it's the last 2 years have kind of really shuffled things up. So the teams I really followed, I'm not really into as much right now. I was a big McLaren guy, but I just don't like their paint scheme this year. Just ugh, the orange is ugly, 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 ugly. Uh, who do you like, Wesley? Are you got any team you particularly like, or are you more of a you follow drivers? Yep, they stay sequestered. So let's see. Uh, that was a question. Yeah, Wesley, just yeah, I won't ban you if you put down you like Lewis Hamilton. Yeah, I was curious to know who you liked, who you didn't like. Hi, Joe. So yeah, we're actually gonna be down for an hour and a half. That's a lot of downtime. I know some of you guys were saying I re-uploaded the Chandler Halverson video. Yeah, there's a little bit of I shut off the sound when the guy's talking at the beginning, and then the court sound doesn't pop in until about the 2 minute mark. So just at the 2 minute mark, you guys can jump in there. Yes, your car is very holy. uh, we have so much downtime, guys. I may put this. I'm just kind of on the download for a minute and then come back to it once we get close to starting back up. I do have some uh, jobs that were requested that I complete by someone that I live with, and she would really like for me to get those done today. So I'm probably going to have to work on those just for a little bit at least. So I have no problem sticking around for a minute, but I won't be able to stick around for the whole hour and a half. If you want to, like the Chandler Halverson sentencing and the Crystal Daniels one back on, but that's about all I can think of right now. Hmm. I have to do some things, Gabby. I have some obligations I gotta do. Put some stuff. I gotta put a chair together and some other things. So nothing too special. Just I have to get it done, and I want to get it out of the way now. Oh, I sound like a robot. Damn it! Hold on. Okay. Do I sound better? So I have to work on. I gotta put a chair together. Uh, I gotta move a couple things around and get some stuff cleaned up. This should work better now, right? I'm not gonna do a build on stream. There's a lot of swearing and whatnot in the meantime. Ferrari and RBR are close this year. Oh yeah, this is Leclerc versus Verstappen. I think that's gonna be a good. Charles versus Max will be a pretty good battle. I don't think Mercedes is gonna have they're hurting a lot. I think it's going to take them a little while to catch up. So I think, yeah, at least for a while, it's going to be Mercedes and Red Bull, and I'm sorry, Ferrari and Red Bull. And I wouldn't be upset seeing Ferrari get back on top. It's been a little while. We kind of need some things to get stirred up a little bit. I will say, like, that said though, Alfa Romeo's looking pretty good too, and Haas, holy cow, they're very impressive. I was very impressed with Haas. So, yeah, guys, I'm gonna go take care of some stuff, and we'll be back in a little while. If you guys want to keep chatting, that's totally fine. I'll just well, let me see if yeah, there's not a view I can put on. Let me see. Is there? Would you guys like? You know what I'll do? I will restart. I will go back through and find the ABC 24 play of this beginning in the morning, and you guys can watch that. How about that? Does that sound like a deal? Because they said this is hour and 12 minutes. Yeah, how about that? We'll restart the morning. I'll restart the morning stream, and that way we have it all on here, okay? Sound like a deal? Sound like a game plan? So there's an hour we haven't watched. So here we go, guys. Let me put that up. Well, actually, wait, they haven't put it up themselves. Here, hold on. Oh gosh, we may have to go to Cuck and Law and Cuck to do this. All right, let's see. I really don't want to use them, but you know, whatever. Okay, you know what? We'll as much as I hate this, I will use Long Crime and restart their stream from the beginning, and that way we can watch. Okay. Let me see if I can find what they're doing. Um, let's see here. Day 4, day 4, day 4, day 5. Yeah, no, there's nobody has anything up yet. Sorry. Well, they restarted their stream. It looks like they have day 5, but it's been from looks like they had the clock start at noon, so they killed their old stream. And remember, guys, this undercover cop that they had on, remember, Jimmy Martin's really the guy who, you know, he talks about the whole thing going down, how it got planned and what happened. That's really where I would you know, that's where it's going to happen. Okay, KLF, do you have that, or can you do you know the name of that guy? I can put that on if you guys want to see it. Oh, George Real sentencing by Judge Borowski. All right. Okay. And the people want this. I'll run it. G.E. George Real sentencing. Okay. All right. How long is this? Hour and 20 minutes. All right. I'll put this on. I will make the people happy. And I will be back.
These cases are here today for a sentencing hearing. There was
Enjoy.
a state pre-sentence investigation filed after a delay. There was also documentation filed by the defense. Are both sides ready to proceed?
Yes.
Yes. All right, first of all, has the state complied with victim notification?
We have, Judge.
And can the state outline the agreement or negotiations in this case, please?
Yes, Judge. In this case, the defendant pled to 3 counts. 2 of them are on the homicide case. In that case, he pled to count 5, homicide by a restricted controlled substance in the blood. That's a Class D felony, punishable by up to 15 years of initial confinement, 10 years of extended supervision. He also pled to count 4, which was amended to a second-degree recklessly endangering safety for his 2-year-old passenger, B.W. That's a G felony, punishable by up to 5 years of initial confinement and 5 years of extended supervision. And on the other case, 20 CF 2731, he pled to fleeing or eluding. It's punishable by up to a 1.5 years of initial confinement, 2 years of extended supervision. All other counts in the 2 cases were dismissed and read in. The state's promise in exchange for those guilty pleas was to recommend today substantial prison, length to court. That's the recommendation I plan to make.
Counsel, is that correct?
Yes.
All right, I'll hear from the state.
Thank you, Judge. I'll begin by talking about the gallant factors, starting with the defendant's character. Much of his record prior to these string of incidents is fairly minor. He was convicted in 2015, CM 3483 of carrying a concealed weapon, got a 90-day sentence. Before that, in 13 CM 3990, he had 2 counts on the case, entry into locked vehicle and misdemeanor theft. Was originally given a DPA. The DPA was revoked. He got 50 days imposed and stayed for a year of probation. One case in his history, however, Judge, is obviously significant to our sentencing. That case is 16 CF 3779. In that case, Mr. Real was convicted of hit and run causing death. The sentence will jump out at you when he got a year imposed and stayed for 18 months of probation. And I think that makes sense when you see the facts. In that case, according to the criminal complaint, there was a crash at 27th and Wells between a red Honda and a white Infiniti. Whole cameras show that the red Honda had blown a red light. The Infiniti had a green light and struck the Honda in the intersection. The Honda driver had meth in his system and was convicted of OWI causing death. And the Honda wife's passenger was killed. Judge Wagner gave that driver 24 years of initial confinement and 36 years of extended supervision. The defendant was driving that other car, the Infiniti that had the green light. He told police he had borrowed it to go pick up his sister. After the crash, he ran from the scene, according to him, to tell the car owner about the crash before he was arrested. He then returned to the scene and told the police about the accident. As a result of all that, he was convicted of the hit and run and got the probationary sentence. On the one hand, Judge, the state used that as about as mitigated of a hit and run fact pattern as I can imagine. So I'm asking for what weight you do put on that, you take the facts into account. But on the other hand, Judge, it's about as severe of a wake-up call as someone could get. You're involved in a car accident that caused someone's death, you're criminally charged in it, you receive a light sentence that's probably warranted on the facts, but all that should teach you about the importance of staying on scene, it should teach you about the importance of driving carefully, and it doesn't seem like this defendant got either message from that case. In our case, Judge, there's 2 incidents. The first is 20 CF 2731, where it's pled to the eluding charge. In that case, on August 7th, the defendant was going about 60 miles an hour in a 35 on Capitol Drive, passing cars. Patrol officers attempted to pull him over. There was a 5.25 mile pursuit that reached 100 miles per hour. Officers reported 5 different red lights blown. The defendant going into oncoming traffic at one point. And eventually officers terminated that pursuit for the safety of the public. 23 minutes later, the defendant's car was spotted again, this time with no headlights. Police officers chased him. He eventually fled on foot. A .22 caliber pistol was recovered in his flight path, and when he was caught, he admitted to being the driver in the earlier chase. Obviously, he's a felon based on that earlier conviction. That wasn't, there was no felon possession of a firearm charge related to that. He was charged with second-degree recklessly endangering safety, which has been read in here, as well as the eluding charge, which he's pled to. Those charges were pending before Judge Yamahiro. He was released on $3,000 cash bail. His conditions of release included no driving. He was revoked, I believe, at the time of that offense as well. While he's out on those no driving conditions, we have our second incident. This is New Year's Eve, afternoon of the 31st of December in 2020. As I said, he was revoked. He had no driving as a condition of his bail. There was a man with the initials of RP who was driving eastbound on Burleigh through the 60th Street intersection. RP had the green light. He was struck by this defendant, and his car hit the victim, pedestrian, a Mr. Arthur J. Baker, who was killed almost certainly instantly by being struck by that car. Mr. Baker was a 36-year-old man, so just, really in the prime of his life. You can see from the letters which we submitted from his daughter and his sister what he meant to his family. I should note, Judge, his mother, Miss Lanell, Lanell Williams, is present in the gallery behind me to my right. She doesn't wish to speak today, but just wanted to thank you for your time and ask for a just sentence for what happened to her son. Moving back to the crash, in the defendant's car, in the front passenger seat was a woman named Damani Hurt. That's Dhimone, last name Hurt, Hurt. Her 2-year-old BW was in the back seat. BW got a broken tibia, was not in the child safety seat. When police spoke with Ms. Hurt, she originally said that Rio had been involved in a meat-mining incident with another driver in a red van who lobbed a shotgun at them. However, in a subsequent Mirandized interview, Hurt told Detective Mueller, Mueller, that statement was a lie, that Rio had instructed her to give a fake story because he always drives like this, and he had justice point conditions. She also said that she had warned him in the past about driving recklessly and had yelled at him for that type of driving. The defendant's blood was taken. He had an amount of THC, Delta-9, or restricted controlled substance in his blood, which is the basis for the count 5 charge that he's pled to. Judge, I've told the family I'm not going to play the video of the incident. I've got 2 angles. They're both very short. I'll submit the CD. This is, I believe, the first file on the CD, which I'm playing first. I've got it up on the television. The victim's car is one of these cars that stops at a red light. Now turn green, you can see the victim's pedestrian is walking over here. See the other drivers, one of these cars. The defendant's going to be driving through the intersection. This angle is mostly so you can see the status of the lights at the time of the crash. Got one other angle. In this angle, you can see this is the crosswalk where the victim's properly walking with the green light. You're going to see him pause here and kind of glance for a second, make sure it stays with the Judge, the crash reconstruction officers from the Milwaukee Police Department believed the defendant's speed was somewhere between 60 and 80 miles per hour as he approached that red light. With my limited experience, that certainly seems
low based on what I just saw. Certainly wasn't 60, might have been 80.
the speed limit on that street is 30 miles per hour, so he was traveling over twice the legal limit. In his statements to officers, the defendant initially claimed that Ms. Hurt was driving and that they had fled because another car was shooting at them.
So you can correct me if I'm wrong. The defendant lied through his teeth about what was going on when he was driving and killed somebody. That was his first reaction.
That's true. He then claimed that they were fleeing another car, but admitted that he was driving and that no shots had been fired. And he did write an apology letter to the victim's family that contained that statement that they were fleeing some other car. As you can see, Judge, the other car that he's described, I didn't see any evidence of it in the video. Ms. Hurt said that that was a made-up statement. I know we've had other cases in this court where that sort of information was found to be credible and was true. This case, from everything I can see, that statement is unsupported by any other evidence. Judge, and lastly, on the nature of the offense, the most important part of this, or really any other case, for what the case is the life of the victim. I mean, there's a 2-year-old with a broken tibia, but as you can see from the video, Mr. Baker is just walking. He has the light. He pauses at the median where he should be safe. He's looking both ways. And now you've got this letter from his only child, his daughter, who says, quote, "Knowing that I'll never even be able to have a conversation with my father again hurts my soul. I'll never get to visit my father on holidays or any other day ever again. Nor will I be able to get a congratulations from my father when I graduate." You've also got the letter from his sister talking about the closed casket at the funeral because of the injuries that Mr. Baker suffered in this crash. And really the only positive I see there is that it was certainly over in an instant. The sister's letter is right. This defendant appears to lack insight or empathy. And it's unclear to me how anyone could have that first brush with the law in a traffic case and still be out driving like this. The last consideration under the Gallant case, Judge, is the need to protect the public. You can see from the traffic, from the video, how busy that intersection was that day. It's 1:52 p.m. on New Year's Eve. Plenty of drivers, at least that one pedestrian. And if you think about how everyone feels on New Year's Eve, you're kind of rushing around, looking forward to the evening, looking forward to the new year. And Mr. Baker never got there. He doesn't get a new year or any more new days just because this defendant was in this mindless rush. And looking at that video, I think about Mr. Baker, but I also think about all those other drivers, not just the one that he hit, but if you're traveling at that speed through that busy of an intersection, someone's going to get hit. And it's not just that he happened to hit a car and that hit Mr. Baker, it's that he was endangering everyone at the intersection, and it was going to almost certainly end badly for someone. And the public needs to be protected from driving like this. Judge, you've got the victim impact statements where both the sister and the daughter asking for I believe they both asked for the maximum sentence. The state's recommendation today is simply for substantial prison. I think substantial prison is necessary to protect the public going forward in this case. I'm asking you to follow that recommendation.
Thank you. Counsel?
Thank you, Judge. First and foremost, I'd like to offer my condolences to Mr. Baker's family. I know his mother is present in court today. These sentencings are always very difficult. You have many lives that have been destroyed as a result of this case. And ultimately, Your Honor is tasked with trying to bring justice in the true sense of justice. Anytime a life is taken, it's tragic. This was a horrific accident. And that's where we find ourselves today. Mr. Real is 25 years old, and I think the PSI, as well as what I provided to the court, describe a life that has never really been on track to be part of normal everyday life that most of us experience. Mr. Real's life started being born premature to a 14-year-old mom who was using drugs and alcohol at the time. He suffered physical abuse. He witnessed horrific trauma as a child. And so that's where he started. That's where his life began, was somebody that was gonna have a real hard time getting a chance to be successful. Throughout his life, he's experienced significant trauma, a lack of guidance, a lack of role models, a lack of focus, and even while dealing with this case, Mr. Real has had to stand on his own. The guidance that he was receiving from his family, he chose to disregard in this case and accept responsibility, which I think shows that at 25, he wants to do the right thing and wants to be a man. I know that his family was angry with me, angry with him, that he chose to enter a plea. I don't even think they showed up as a result of that, and that's the network that he has for him.
So the network he has, get him out, deputies out. His phone's gone off twice, he's disrupting court, take him out.
Cause he said his dad here? Oh, crazy. Oh, we already knew what y'all did. That was a big over city.
So, Mr. Levine, not that it matters directly related to the sentence, but his family's guidance was what? Take this to trial, and the state has the homicide vehicular on video.
What I can tell the court is it was poor guidance in my professional opinion. And Mr. Real, to his credit, stood up to what he was being advised to do. And he's standing on his own today. And I think it's never going to change what happened. But at some point, Mr. Real is going to be released from custody. And at some point, he's going to be in our community. And what we want for people is to change. And in terms of that, what I was talking about related to his support network, if I would even call it that, while struggling in school at a young age, rather than encouraging him to stay in school, get educated, he was advised to leave now. He left after the 9th grade. And this is somebody that clearly had learning disabilities and mental health problems along the way. And rather than getting him the support and the treatment that he needed, they just put him out on the street to fend for himself. And I think he's been fending for himself basically since birth, but without the tools necessary to do that in a productive way. I don't know what the right answer is because certainly this is a horrific accident. What I do know is that you have a young man who is remorseful, who wishes he could go back and make the right decisions. He certainly didn't wake up that morning with the intention of ending Mr. Baker's life. The day started with going to get presents for his girlfriend's daughter. That was where they were headed that day. Now, I understand the court may choose to dispel what Mr. Real believed was going on that day and whether or not that was reality or in his imagination. That's what he told police. That's what he has indicated, that this started off with a road rage incident that culminated in him recklessly driving. He has a history of poor driving and reckless driving, and that's something that this case is hopefully going to prevent in the future, and that he loses his license for 5 years. Pleading case, he loses his license. And really, he's not somebody that can be trusted right now behind the wheel of a car. And I know that the 2016 case jumps off the page to the court, but here again, Mr. Real is in a situation where he's got this history that's going to follow him around forever. And so coming before the court now, I understand it's hard to process. But I do believe that Mr. Real is empathetic, despite what has been alluded to. I know that he suffers from nightmares and traumas from this incident, and I'm not saying that isn't something that should come with it, but it's something that he's dealing with on a daily basis. He has periods of lucidity and other periods where he's kind of zoned out of it, and I don't know if that's related to his medication, his mental health, but what I can tell the court is throughout his life, he's really had very little treatment of any kind. So you've got somebody who's very uneducated, who has significant mental health issues, has learning disabilities, and that's where he sits right now at 25 years old. To his credit, he has been able to maintain a job. He had his own apartment that he was paying for, and he was moving in the right direction. Unfortunately, he chose to drive again, and that was an intentional choice that day. He chose to speed that day. That was an intentional choice that day. But I certainly believe that he did not intend at any point to hurt anyone. And whether he recognized the seriousness of his conduct that day, he certainly didn't appreciate the seriousness of it that day. But as we sit here today, I know from speaking with Mr. Real over the last year that if he could do anything to make things right, that's what he would do. And he's indicated that he wants to honor Mr. Baker's life by never being in this position again. But beyond just not being in this position again, he wants to get educated. He wants to try and make a positive impact on the community. But this is somebody that needs help getting there. He knows he's going to be in prison for a period of time based on the nature of the charges, at least as it pertains to the homicide count. He's not eligible to get some of the programming that would benefit him, like a boot camp situation that would give him some discipline, teach him some basic skills. And so he's going to be sitting, and the question is while he's sitting, how's he going to use his time? How is he going to honor Mr. Baker's life? And that remains to be seen. Talk is cheap until you actually do something. You've got a 25-year-old kid, and you have lost the life of a 36-year-old man. And Mr. Real really has not matured to the point where I can call him an adult. On paper, he's an adult, but he certainly has a long way to go, and again, he's gonna need a support system, and he's gonna need a support system that actually cares about his well-being and helps guide him in a way that he can be a productive member of society. And that's what ultimately his sentence should try to accomplish, is to provide those tools for when he's released, that we know that he's gonna not be a danger to the community, that he's gonna take care of his responsibilities and not continue to be a burden on society. He has one daughter who he loves very much. And when we were talking about the time that he's going to be away, on his own recognized the fact that Mr. Baker's daughter is not going to have the chance to see him again like his daughter will see Mr. Real again. And I think that awareness is again George's path to maturation and to accepting responsibility and putting himself at the mercy of the court in this case. I don't know the guy that was driving that car that day. When I meet with Mr. Real, he's docile, he's polite, he's attentive, he's interested in his case and the outcome. But I think he struggles, and that's where he needs to really stand on his own and make changes so that we can trust that when he's out, that the community is going to be safe. He has interests. He wants to go to school. He wants to pursue certificates in being an auto mechanic. He's been working as an orderly or a medical assistant in the nursing homes. And that's the exact opposite of this day, is he's being tasked with caring for the elderly and making sure they're getting their medication and making sure they're safe. And that he was good at doing that. But that's in a structured setting where he knew his tasks and he wanted to do right. Judge, any homicide case is hard. We have, like I said when I started, we have many lives that get destroyed when someone loses their life on so many levels that the ripple effects just keep going. I'm asking the court to consider a sentence that does a couple things. Number one, that Mr. Real gets the confinement time that is necessary to send a message to the community that this behavior will not be tolerated, and to punish Mr. Real for his conduct in these crimes. I'm asking the court to consider quite a bit of extended supervision, because I think having that umbrella over his head will ensure that he follows the right path, that he follows the rules, that he follows the law, and that the potential to go back to prison at some point is enough to keep him on that path. Because he, like I said, is going to be alone at this and needs that structure. He's not eligible, as I indicated, for programming based on the 940 offense. And so I think the court could structure the sentence in a way that he serves his time in that case up front, but then may get the opportunity on the other cases or on the other counts to get some of that discipline and programming and substance abuse treatment that he so desperately needs. Because what the PSI didn't say is related to his substance use, which clearly he has marijuana in his system, which formed the factual basis of this plea. He had been drinking to try and cope with daily life. And so I think there are substance abuse issues that need to be addressed. He's managed, while in custody, obviously, to remain sober, and he appreciates the fact that he's able to do that. But again, while in custody is a different thing than on the street, so getting those tools will help him when he gets released. Judge, I'm asking you to consider 8 to 9 years of initial confinement, followed by 8 to 9 years of extended supervision. It's a 16 to 18-year prison sentence. I think that is sufficient for the crime that's been committed. No amount of time is ever going to bring back Mr. Baker. And hopefully, Mr. Real can do what he's saying by making something of his life and being a dad and doing right, and so that Mr. Baker's life wasn't lost in vain. Maybe his life can save another life at the end of the day. And that's how Mr. Real would honor his life, by doing that. That's all I have, Judge. Thank you.
Introducing White Claw Surf, a whole new wave of White Claw.
Does your client want to make a statement?
He does.
Good morning, Your Honor. I want to start off by apologizing to the family of Mr. Baker. I am sorry and will do anything to go back in time and change things. I never meant for anybody to get hurt or killed. I don't want anyone to feel sorry or have sympathy for me. I just want people to understand what happened that day. I understand I should have not been driving at the time, and I take full responsibility of that. Me and my family were victims of a road rage incident. The only thing that was on my mind was getting me and my family out of harm's way. Okay. The only thing that was on my mind was getting me and my family out of harm's way. I never meant to harm or hurt anyone. This incident lives with me every day, and I will never be able to escape it. I want to use this time to become a better person, a more responsible person, and make something of myself to honor Mr. Baker's life. I also want to use this time to be productive and better my education and myself. I am not a bad or reckless person, and I want people to know that. I am asking that the family of Mr. Baker can find it in their hearts to forgive me. That would really mean a lot to me. Thank you.
All right, in looking at this case and fashioning a fair and appropriate sentence, looking at the gravity of these offenses, and there are multiple offenses, the defendant's character, the need to protect the public, along with things like punishment, deterrence, and rehabilitation. Mr. Rio, you are the poster child for two of the biggest problems we have in the city of Milwaukee and Milwaukee County. Not just reckless, but ruthless driving and people being assigned bails that are too low. I don't believe for 1 minute did you have any remorse over killing a pedestrian.
I'll do it.
No, you had your chance. I do not believe for 1 second, Mr. Rio, that you have any remorse. The PSI, the state pre-sentence investigation, noted on multiple occasions that they would ask you a question and you'd say, well, is the judge going to see this? Was the judge going to read it? Is the judge going to see it? And then you would answer accordingly. Mr. Rio, you're a menace to society. You're a menace to Milwaukee County, and you deserve a lengthy prison sentence. Deputy, take that gentleman out of the courtroom as he now just pulled his cell phone out. I presume to record. Take him out of the building.
Check the top. George, I know you ain't do that shit. They see what car was gonna stop it out of here. I'll check it over. I'm sorry. Hey. Let's go. I'm not even doing that. I'm not even doing that. Give my phone. Give my phone. He ain't doing his job. I ain't even doing it. It's funny. This is what they like to do. This is what they like to do. I don't even care. It's funny as hell.
Let go, here. Let go.
Calm,
Relax.
It's pissing me off, bro. Relax, man. You be all right. Man.
We're taking a recess.
I will just state real quick, guys. I've been listening on my phone while I've been doing stuff. Somebody mentioned, "Oh, this isn't helping the defense. Defense is not helping." That's all you got. You got to point out, "Oh my gosh, it was so hard for him." You know, growing up in a shitty life made him drive like Helen Keller. So, that's, you know, I've made those arguments before. Look, Judge, it was really hard on him, and he really had a rough upbringing. That's why he ended up, its environment caused him to run around and do stupid shit. So that's not uncommon. I will tell you that is not uncommon at all. You work with what you got. If you don't got much, you got to work with it. Yep. As a very famous guy on YouTube says, you got to piss with the cock you got, and if you don't have a big cock, you're not doing a whole lot. Hey, Playmaker. It's been a little while. Glad to see you back. So. Oh, there probably will be a contempt for that penalty, and the court will figure out what's going on there. He may not say disorderly conduct. Who knows? Toxic, that's all you got is to pull the pity party. But yes, if you watch that video, yes, him driving like Helen Keller through an intersection. Yeah. Oh, I was so sorry. I was so scared. It's like, okay, well. And then you lie about what exactly happened. Like, just admit you're driving like a moron. But yeah, there's nothing you can do. The judge has already made up his mind. This is damage control. And you hope it works. Oh, here we go. Shannon, I fully agree. He chose this outcome. Okay, Playmaker, I will tell you this much. I guarantee you he is professional if that is not enough. that is not on him. That will not be affected to him. Yes, I think I've seen that before, but yeah, Judge Borowski's just, he takes a break and he's like, I just, and that's the professional thing to do. Just get out of the courtroom, let everything subside. It chills everything out once the judge leaves the courtroom. Everything dies off. So, I don't, that's not him going in the back to like go hit a punching bag or something, or go kick his dog. No, he's just, that's a very common thing for judges to do. I'm going to take a break. And we're going to chill out for a minute. So. But he's not even regrouping. I guarantee he's 100% fine right now. As soon as he said we're taking a break, he was fine. But it prevents the appearance of impropriety from being alleged. Ooh, they called in some more guys. They called in some detectives. Also, so you guys know, this is not a COVID precaution. All this glass, that's bulletproof glass. I'm assuming Milwaukee's had some issues in the past. Mm-hmm. Oh, toxic. We know what you mean. Well, yeah, kind of like that, Kay. But there's not a worry of Borowski shaking him to death. But yeah, just you let everything chill out. Okay, so I'm back. I have the feeling Judge Borowski's taking care of errands right now, so why don't we skip ahead when he gets back?
This is the water. This is the only water that is available to this village.
The solution is surprisingly simple, and it's already been implemented in this Central American village.
No, I haven't heard about that one, Toxic. Oh, it's gonna echo again for you guys if he starts talking.
All right, we're going back on record on real. The appearances remain the same. We took a break of about 10 or 15 minutes. There was a disruption in the courtroom. He was making an obvious a friend or associate of the defendant and took it upon himself to first take out his phone and, it was my belief, potentially record or take photographs. When he was about to be removed, he reacted extremely violently and was removed by the bailiffs.
Treat us sack because the jury's sequestered. They want to get it done and keep things going.
I'm going to pick up where I left off. Mr. Real, you are the poster
Thank you for joining
child
us.
of the biggest problems we have in Milwaukee County. Reckless, ruthless driving that kills people, and the bail issue we have in Milwaukee.
Oh, shit.
Neither of them has been adequately addressed. And as I was saying, Mr. Real, I do not believe that you're remorseful because you read me a 3-sentence letter. I don't believe that. You are remorseful that you're sitting there facing a lengthy prison sentence, maybe. But let's start off with a number of things. Your attorney said you're a kid. You're not a kid. You're a 25-year-old grown adult who has no respect for authority, no respect for the law, no respect for human life, and participates in the carnage that goes on our roads. The homicide in this case, and I watched maybe a grand total of 30 seconds of video, was horrific. You were completely unmoved by watching that video. I saw your reaction or utter lack thereof. That is the kind of video that would make most people flinch. As you go flying through an intersection at the state's estimate from the officers and others was 60 to 80 miles an hour. If anything, it certainly was on the high end of that. It's a busy intersection, midday, broad daylight. You come flying through the intersection, plow into another car, and literally obliterate another human being. The poor victim in this case was crossing the street, minding his own business. He had a bag in his hand like he's just going to Walgreens or a store. And as the state pointed out, and as the video showed, he even paused for a second in the intersection to glance around. Because that's how bad the streets of this city are. And less than a second later, you took his life. The victim, Mr. Baker's sister, that writes, well, they had to have a closed casket. I'm not surprised.
Yeah, he got squished pretty bad.
Your apology to the victim's mother who sits here was half-hearted at best.
Trito, just chill out. That's what I can tell you right now, please.
You're an
That's my
absolute
only
menace
recommendation
to
right
this
now. Chill
community.
out.
And I want to read, as part of the gravity of this offense, some of the statements
from the victim's sister. The victim, Mr. Baker, would have been 38 years old in just a couple of months. He was 36 when he was killed. The victim's sister says,
Well, of course I can tell you chill the fuck out. It's my fucking channel. So, if you don't like it, you can suck my thick Irish dick. Okay? Just chill the fuck out. We're all watching this together. We can all be civil.
my brother's death was 100% preventable. The brutal manner in which he was killed was so severe that we had to have a closed casket funeral. My brother's face and body was crushed. My brother's death has traumatized me, especially the way he was killed. She points out, or she believes at least, Mr. Real didn't learn anything from the first murder and was out on bond for driving recklessly, and while out on bond, killed my brother driving recklessly. And she's asking me to give you the absolute maximum sentence. She points out, in terms of aggravating factors, and there's nothing but aggravating factors in this case, Mr. Real. Again, you're an absolute mess. Let's start discussing the aggravated factors. Beyond no empathy and no remorse. You're out on bail. On case 20 CF 2731, which was a driving case to which you pled guilty to fleeing and eluding an officer. You did not care one iota about breaking the law. You did not care one iota about the court order. You did not care at all about the people in this community, the citizens of this community, and the people that have a right to walk down the street and not be killed. In terms of my determination that Mr. Real has no remorse, I don't believe the statement that there was some road rage or some mean mugging going on the day of the homicide. His own girlfriend, who lied for him initially, then backed off and said, no, that's a lie. I'm paraphrasing. Mr. Real was willing to drive this way with a 2-year-old in his car. Talk about that for an aggravating factor. I'm willing to go 70 or 80 miles an hour, driving recklessly, causing carnage in our streets with a 2-year-old in the car. Because Mr. Real cares of no one but himself. No one. Not your own child, not the child that was in the car, and certainly not the people in this community. Let's talk for a minute about the first case to which the defendant pled guilty to fleeing and eluding an officer. Again, highly aggravated in every sense of the word. He starts by going 60 miles an hour, approximately on Capitol Drive. Capitol Drive is ground zero for bad driving, not just in Milwaukee, but in Wisconsin, and possibly in North America. No one should be forced or allowed to drive on Capitol Drive. It is so bad. Now, there's bad driving all over this community, in the city and in the county. I've had cases on the south side of bad driving, on the north side, in Wauwatosa, in Oak Creek, but Capitol Drive is ground zero. It is never safe to drive on Capitol Drive. And why? Because people like Mr. Real take it upon themselves to go 60 miles an hour. If that's not enough, he gets lit up by the police. Then he takes them on a 5-mile chase, going 100 miles an hour, weaving in and out of traffic, shockingly not causing a death on that day. All aggravated factors. The victim's sister points out, and the state discussed it, and the defense discussed it, and yes, the first case from 2016 that involved a hit and run, the sentence in that case does, at least at first glance, jump off the page as being way too light, as being frankly ridiculous. But knowing the judge that imposed it, and knowing the background and the details provided by the state, it appears clear that there was another person at fault in that accident, and that person is rightfully, it would appear, serving a very, very lengthy prison sentence. And both of the judges that dealt with those matters are more than competent. But the point is, Mr. Rito, 5 years before this case, you were involved in a situation that killed someone on the road. You thought so little of that you decided to flee. In that case, flee the scene as part of a hit and run. You got a sentence. That sentence had no impact on you whatsoever. None. Because in 2020, we have the fleeing and eluding an officer. Then you get out on a bail that I'm sure the commissioner thought was appropriate, and I'm sure she used the appropriate factors, and I'm sure she made the determination that she thought was correct. But ultimately, you think so little of that, and that light bail, the small amount, that you then go and drive exactly the same way, if not worse, this time killing someone. The victim's sister makes some other comments that are very salient to the point. She says, his lack of empathy and poor discernment should have taken this matter serious. She's referring to the 2016 case. She goes on, unfortunately my brother was killed, but all of the lives put at risk that day should not go unnoticed. There was a 1-year-old child in the car who suffered a broken limb. His girlfriend was severely bruised and scarred all over her face. Mr. Rito didn't care enough for the 2 people in his car with him or the public safety to slow down or to not drive. Again, showing an utter and total disregard for law, for authority, for human life. This defendant and the victim both have young children, or a young child. But as the victim's sister points out, her brother, who's killed at the age of 36, in an instant, will never see his child again. Mr. Rito, while he's serving his prison sentence, can see his child. Though candidly, there is nothing other than bad examples set by Mr. Rito. And I'm not making this part of an order, but I would hope Mr. Rito's child does not see him. Because Mr. Rito, you're the worst example we have in Milwaukee County for the awful, terrible driving and killing people on the roads, carnage on the roads. Looking at some other factors, yes,
He hold back.
He certainly did not have the best upbringing. His mother was too young when she gave birth to him. The defendant was not raised well. That is obvious. His parents on both sides were failures, either from not trying or not caring, or maybe some other reasons. But Mr. Rito was not raised well. That's certain. and that's unfortunate. It does appear from the PSI, and if Mr. Beal's friends here in court are any indication, that he has hung around with and surrounded himself with bad, maybe not bad people, but people that give him bad advice, to point him in the wrong direction, to tell him to do things that are bad, to tell him to drop out of school. But Mr. Beal took the bad advice for years and years and years. Again, just to be clear, I've read every single thing that's submitted, the state PSI, the defense submission, the letters. The defendant does deserve credit for pleading guilty, but I will point out, and I will read them into the record, there were multiple charges dismissed and read in. Multiple charges. The defendant was facing far, far more in prison time under the original allegations on these two cases. And that consideration has already been granted to the defendant by the state.
See you, Sue. Yeah, you're not going to miss much for the rest of the jury instructions. You'll be fine.
It happens more than once, but in the PSI on page 16 of an over 20-page state pre-sentence investigation, the defendant was asked how he perceives the criminal justice system. And then, as the writer points out, says, "We want to know if this answer is going to be known by the judge."
Oof. Yeah, we'll talk about that.
He does that more than once with the PSI writer. That makes the pre-sentence writer, the investigator, I think it's fair to say, suspicious of the defendant's motives. I give the compass very, very little, or I should say limited weight, but that tool indicates that the defendant's risk for violent recidivism is a 9 or a 9.5 on a scale of 1 to 10. And his recidivism risk overall is an 8 or an 8.5 on a scale of 1 to 10. I disagree with that. If Mr. Beal was released anytime in the near future, his risk of recidivism is a 100% guarantee that he'd be back on the roads recidivating and driving badly and driving recklessly. And again, it's in some ways slang, it's not a legal term, but this is ruthless driving. This is utter disregard for human life. Not caring about another person in your car. Not caring about a 2-year-old in your car. You're willing to go 75, 80 miles an hour, not caring about people in your own life, let alone Mr. Baker, who's walking down the street, minding his own business. And his life is taken in an instant. So he doesn't get to see his child. He doesn't get to have a 40th birthday party or a 50th birthday party, or see his mother, or see his family. I'm sure he had plans for later that day. And I doubt, this is sad, but I doubt that he told his child, "I love you," in the sense that he would think, God forbid, I'm going to be killed in the middle of the day, broad daylight. Because Mr. Beal is behaving in a despicable fashion on the roads. And yes, the defense pointed out, Mr. Beal has said more than once, well, he didn't intend to kill Mr. Baker. Well, no. But Mr. Beal, your driving is the equivalent of spraying a gun into a crowd and saying, well, I didn't intend to kill anybody. Your driving was utterly reckless, ruthless, dangerous. It was certain to kill someone at some point. And the sentence you received in 2016 is what it is. You're not being sentenced for that case, you're being sentenced for what you did in these cases. But the victim points out, I think the state alluded to it, and I certainly believe the fact that that 2016 case did not affect you at all. It did not change your behavior for the better. It did not make you care one iota about the rules of the road. Not at all. Just so it's clear, in terms of sentencing, the defendant has already received significant consideration from the state. He did plead guilty. He deserves credit for pleading guilty. But on the 21 CF 032 case, count 1, which was a second-degree reckless homicide, was dismissed and read in. Count 2, knowingly operating while revoked, was dismissed and read in. The felony bail jumping was dismissed and read in. And the causing injury while operating with a controlled substance in his blood or on his person was also dismissed and read in. In a case 20 CF 2731, the second degree recklessly endangering safety, which has a much lengthier potential prison sentence, was dismissed and read in for a plea to the fleeing or eluding an officer. I've discussed it at length now, but I want to make it very clear. Mr. Rio is an extreme danger to the community. He's an extreme danger. In fact, I think he's a certainty to reoffend. He needs a lengthy prison sentence to protect this community. Mr. Rio needs to be taken out of the community for lengthy rehabilitation. And Mr. Rio, you need to be taken out of the community for punishment and deterrence. You need to understand, this community needs to understand that you behave or other people behave the way you would have in this case, you will serve a lengthy prison sentence. Because Mr. Rio, the bottom line is you're a bad actor. The only thing that can be said here is you did plead guilty. Now, again, the state dismissed 5 counts. You're facing decades and decades of additional prison time, so you received the consideration already. And that is certainly a factor for me when it comes to sentencing. Mr. Rio, on the day in question, December 31st, New Year's Eve of 2020, certainly did not wake up thinking he would kill Mr. Baker, but he woke up not caring about anyone or anything in his community, which is his MO for years.
Well, I mean, yeah, it really makes things worse when you've already killed someone in an accident already, not just you know. Yeah, he didn't do himself any favors here, guys.
Mr. Rio, your attorney said you care about your child. Maybe you do, maybe you don't. But I will tell you this, any semi-responsible adult, any adult with a smidge of humanity would not drive the way you did with a child in the car. That child then suffered a broken tibia and ended up in Children's Hospital. And a decent
Ooh, broken
human
leg,
being,
damn.
let alone someone who's a father himself, would never let a small child be in a car without a car seat. Never. But you are willing to drive and operate the vehicle in a reckless, ruthless, awful, dangerous fashion that killed a completely innocent victim and put a 2-year-old in Children's Hospital. Fortunately, and by the grace of God, the 2-year-old was not killed either, or as well. Mr. Beal, at some point in time, someone, either your attorney or somebody, referred to this as being an accident. This was not an accident. An accident is, I tell you, to take Capitol Drive to 76th Street and turn right, and you turn left. That's an accident or a mistake. An accident is the streets are slippery and icy, you slam on your brakes and rear end another car. What you did, again, literally, in terms of the law, and figuratively, was ruthless, careless, utterly reckless and irresponsible behavior. The need to protect the public is extreme in this case. The need for punishment is extreme. This sentence focuses on protecting the public, punishing the defendant, specific deterrence, and general deterrence. And I've said it repeatedly, but this is a pattern of behavior. Everything from 2016 makes that very mitigated. The state's right, the judge's right at the time it appears, that's very mitigated. And that's a very, very limited, almost non-existent factor in my sentencing. The bigger problem is the habitual behavior in 2020 and in 2021. The repeated driving, the repeated speeding, the repeated being a menace on the roads. So Mr. Beal needs a lengthy prison sentence to protect this community. And he needs a lengthy prison sentence to be punished. And as defense counsel pointed out, yes, even if I give Mr. Beal the maximum sentence, he'll be out of prison when he's in his 40s. He'll have 30 plus years of life expectancy. The victim's life expectancy doesn't exist anymore.
Well, guys, we might be running out of time here. Gabby, I understand that sentiment, but I don't believe, jail and prison does anything because the people still drive without licenses. And, we got enough people in jail for ridiculous reasons, so I'm not sure if that's the right answer.
Ultimately, having looked at all the appropriate factors, gravity of this or these offenses, the defendant's character, the need to protect the public, which is very, very high, the need for punishment and deterrence, both of which is very high, and rehabilitation, which is so needed, but also needs to occur in an institution, because Mr. Rio cannot be trusted on the roads. He cannot be trusted in the next 5 years, not in the next 10, not in well beyond that. In case 21 CF 032, Count 5, I'm sentencing the defendant to the maximum sentence, 15 years of initial confinement, 10 years of extended supervision. That sentence is consecutive to any other case, consecutive to any other sentence.
So yeah, he's getting like 20 years out of this. I mean,
On
makes
count
sense.
4, which is the second degree, recklessly endangering safety, I'm sentencing the defendant to the maximum sentence, 5 years of initial confinement, 5 years of extended supervision. That sentence is consecutive to count 5, consecutive to any other case, consecutive to any other matter. Keep in mind that these sentences are being done at the same time, obviously. So I'm considering them at the same time. And it's my intention that the defendant serves a specific amount of punishment, a specific amount of time in prison that I've determined is appropriate under all the relevant sentencing factors. On case, in the sentence I just imposed, clearly, but it's on 21 CF 032, that's the count 5 and count 4. Okay, case 20 CF 2731, which is the fleeing and eluding. I'm imposing a sentence of 1 year of initial confinement, 2 years of extended supervision, but I'm running that sentence concurrent to a sentence on this other case, concurrent to the case 21 CF 032. That means it's my specific intent that the defendant serves 20 years of upfront time, which is the absolute minimum necessary to protect this community, and 15 years on extended supervision. The defendant is not eligible for the challenge incarceration program. He's not eligible for the substance abuse program pursuant to statute. And even if he were pursuant to statute, he's certainly not eligible for either of them under this court's determination and order. The defendant will be given a written explanation of the determinant sentences in both of these cases. The terms of extended supervision are as follows. First of all, for the first 5 years of extended supervision, the defendant is not allowed to drive a vehicle. Whether he's licensed or not, he is not allowed under the terms of extended supervision to drive a vehicle for the first 5 years. That will put Mr. Real at approximately age 50. Maybe, and I emphasize maybe, at that point in time, he could be trusted behind the wheel of a car. I'm not sure, but maybe. Further conditions, the defendant is to seek and maintain full-time employment. If he's not employed, he's to be in an educational program full-time. He's to pay costs, fees, and surcharges. The state did submit restitution. Can you just tell me what that is again?
There's two things on restitution. We submitted for Miss Latish, Latish Williams, $1,156.55 for some travel, obituaries, and funeral decorations. I'm asking the court actually, and I apologize for this, to order a restitution hearing date. We have an amount from the victim's father who paid approximately $5,000 to $6,000 for the actual funeral itself. We've been unable to get his contact information due to some family dynamics. We expect to get that, and we'll be requesting that restitution in the future.
It's fine. I'll set a restitution hearing sometime in the next 60 days. Further conditions of extended supervision. Mr. Real is to seek and maintain, as I said, full-time employment. If he's not employed full-time, he's to be in an educational program full-time. He is, as I said, not allowed to drive a vehicle, licensed or unlicensed. He's not allowed to drive for the first 5 years of extended supervision.
I'm sure he'll follow that rule.
Uber, he can take a Lyft, he can take a bus, or he can ride a bicycle. He can't be behind the wheel of a car. I'm ordering a mental health evaluation. I'm ordering an AODA evaluation for drugs and alcohol that should occur both in and outside the institution. While on extended supervision, I'm ordering the defendant to maintain absolute sobriety, no use of illegal drugs, no alcohol. I want random drug tests and random breathalyzers at least once per month for the duration of his extended supervision. And I recognize it's a lengthy extended supervision. It has to be, it needs to be, to protect this community. I'm ordering the defendant to pay all costs, fees, and surcharges. That includes the DNA surcharge, mandatory and non-mandatory costs, fees, and surcharges. That's to be paid during the term of extended supervision. Failure to pay would result in a civil judgment subject to collection, forfeiture, and tax interception. I will be in other conditions up to the Department of Corrections for extended supervision. We'll set a restitution hearing sometime in the next 60 days. Mr. Real, in these cases, you have the right to appeal. An appeal would have to be filed within 20 days, and you can discuss that with your attorney. Counsel, what credit does your client have?
I did submit a credit sheet. I think it's 400.
in 5 days or 406 days.
All right, I'll give the defendant credit for 406 days. The 406 days will apply.
So,
to
20 years with
upfront
one
time,
down.
15 years.
Start.
On count 5. In case 21 CF 032. Before Madam Clerk picks the restitution date, anything else from the state?
No, thank you.
All right, I'll pick a date.
It's good for the state.
That's fine.
Well, that's it. I mean, happy trails, George. Been a little while.
Do you want to produce or do you want a video?
My video.
I think we should get ready to switch
Fine,
over.
video. I've completed the written explanation of the determinate sentences in both cases in a minute. I'll get a copy to the defense counsel and the defendant. We'll set a restitution hearing date. All right, we've set the date. What date is that again, Madam Clerk? Fine. We're adjourned. Thank you.
Well, that's it. So yeah, I mean that's the biggest problem was he already did this once. He killed somebody already in a car accident. Then he had the fleeing from police. That's the big problem here. That's why he got hammered. If he hadn't, he probably wouldn't have been too bad off. But it's that prior issue that you apparently didn't give a shit is what killed him there. But does it really matter when you know you're going to get hammered anyway? So what emotion does it? The judge doesn't care. Might not be worth it to. Well, Shannon, a need to protect the public and need to punish the defendant. Those are terms of principles of sentencing. Protecting the public, protecting them from, and deterring new conduct, but also punishment. So, I know it sounds good, but that's a normal. That is a normal issue for a normal issue and principle and purpose of sentencing. So, still waiting on things to pop up. The judge said he showed no emotions, but yeah, like I said, does it matter what emotion you show at that point? I mean, it sounds like you're going away all day anyway, so what does it matter? I mean, do you think he would have changed it at all? I don't think so. I'm not believing it would matter. So I mean, yeah, I really mean that. Also, what I said earlier about should we put these people like him in jail for driving without a license? I don't think you should, because after a while it turns into problems with all that. So I don't think you can. So it's, I think it's problematic. There's no easy answer. I mean, I'm curious to know what you guys think might be other options, but like I said, I don't think jail and prison is necessarily the option for people who don't drive. I mean, the amount of people who don't, God, it would never end. We'd have to build jails just for that. And Florida tried this. They have a felony driving without a license statute, driving while suspended. It blew up their prison system because people were like, oh, we should put them in prison. Well, there are a ton of people that do that, and they ran out of room. They overcrowded their prisons doing it. So defendants are usually told to stay neutral. What do you mean by staying neutral? I'm a little curious. Kickstarter, what happened in his other case? It sounded like he got a very light sentence, if anything at all. And that was like 5 years ago. So Obviously, he wasn't in prison at the time because he would have killed someone. Oh, no, you can be, when it comes to sentencing, I don't think there's anything wrong with being emotional. It's showing the judge that you have some emotion. It might help you, but in his situation, he had already killed someone doing this. I assume similar facts, driving like Helen Keller. And then he ran from the cops, so it doesn't matter. He was going to get... Borowski was going to kill him no matter what. So I don't think it mattered too much. Yeah, I just don't think it would have mattered at the end of the day. So let's see. Where are we at? Has anything started up yet? Has ABC started their feed yet? Still no. Let's see what Law and Crime is doing. Yeah, Kay, he was, I agree, he was up Creek. He was already up Shit Creek. Yeah, sure, that's my experience, you know, how many people drive without a license. I remember I was out of law school and I was in the public defender's office and a guy, it was like his 40th time driving without a license. Like, he didn't care. So, you know, what do you do with somebody like that? Nothing stops him. So... So, let's see. I don't know what you guys want to do. It's only going to be a couple of minutes, so I think we should just keep waiting. I don't want to start something new. So. Let's see. Come on. They got to be starting soon. This is a bit ridiculistic. Yeah, he won't be driving for a while, but I mean, as soon as he gets out, you know he's going to drive. Catherine, I agree, but like, what kind of programming would have protected us from this? I don't think anything. I don't think anything would have helped there, so... At least that's how I kind of think about it. You know, what would have fixed that for him, and you know, tell him not be an idiot. But I don't think it would have mattered. So. Yeah, I mean, I don't know. I was just thinking about this personally. Just, you know, what could you have done to help this guy? And, you know, don't drive like a moron. I mean, really is the big thing for him. I don't know how much, you know, like social working and programming you could do to fix that, because it's literally like an impulsivity issue for him. And Kay, that first time through, an 18-month sentence, that doesn't sound bad for an act like a driving, stupidity-induced driving death. I mean, 18 months is enough to make most people realize, wow, I don't want to do that again, but also enough to make them like own up for what they've done. But it's clear for this guy, none of it took. So the 15 years makes a lot of sense now. So So, like I said, I just don't know how you fix it with this guy. Just looking at some of the things here. Yeah, there's too many morons on the road, but we'll never get around that. Okay, I think it's about game time here. Let's, see if we can get ABC Memphis just to, I'll just put us on the seal because I don't know what else to do for this time right now. So,
For the record, this continuation, State of Tennessee versus Billy Turner. Mr. Turner's present.
okay, come on,
All
ABC,
trial
get
parties
started,
are
bro.
present. We're still scanning people to get into the courtroom. And for the record, before we took the break, we made copies of the charge for the lawyers. Mr. Turner, and also some of the media outlets asked whether or not they can get a copy of the charge. Recommendations. Need to put this on the record also, so it would not be any sort of an ex parte communication. But Mr. Here, Mr. Thomas, the last witness that you called, Miss. Yes, sir. Thank you. I actually ran into her this morning as I was coming into the courtroom, to the building rather. Miss Jennifer Bogan, and she was standing outside of the elevator, passed by, and didn't know who she was. And just the way I was raised, looked at her and said good morning, and she said good morning, and realized a few minutes ago that's the same person that used to put on the witness stand. So that's the extent of the conversation. Said good morning to her, and she spoke back and said good morning, and I walked past her and got on the elevator. So I just want to put that on the record. I did tell her good morning this morning. I had no idea that she was going to be here as a witness. Yes, sir.
See, I like that judge taking care of business in an effective, efficient
Are
way.
both sides ready to proceed? And again, based on the communication from the jury, what I'm going to do is read this jury charge. We'll read it in its entirety. Normally we read the first 24, 26 pages, but I will read it, the entire jury charge, so that we'll not have to read in the charge on Monday morning, and we will recite this jury. And we'll start with jury arguments at 10 o'clock on Monday. Again, I have to qualify the March term Shelby County Grand Jury for the next 2 months, and that would be at 9
Shelby
o'clock,
County?
and we'll start jury arguments
Shelby
promptly
County?
at 10. Jeff Smith, you can bring in the jury, please, sir.
Yes, sir.
So what's the judge doing now? Oh, we're all just reading through, having a smoke and a joke. So, toxic you ordered, and what is lawyers are beginning appeals on what basis? That the conviction wasn't right. There were problems with it. I wouldn't know because I'm not the person doing it, but probably ineffective assistance of counsel, any number of reasons. But yeah, they're gonna put together an appeal, and when it comes out, we'll definitely talk about it. I think it'll be interesting, but we'll have to wait till then.
Thank you, ladies and gentlemen. Everyone can be seated. Judge Smith. Pass this to the jury for me, please, sir. 7 and 7. Thank you. Ladies and gentlemen, the evidence in this case has been completed, and these are your final jury instructions. Again, you have your own copy. I'm sorry, it's not a copy. You have your own jury instructions. Don't copy those originals. They're identical to the jury instruction that would be in the court's jacket. They're all signed in blue ink. You can write, highlight, underline.
Most boring part of the day. This is gonna suck, guys.
And again,
Sorry.
I wish I could just tell you to read this for yourselves. When you get back to the jury room, we are required to put this law in writing for you. And it's interesting because when I first started practicing law in Tennessee in Shelby County, we did not used to give jury written instructions. In fact, judges didn't even used to put them in writing, they just read to them. So we changed the law to make sure that it is in fact written. And I give you a copy of the instructions, so if you have a question about the law, once 12 of y'all start deliberating, you can look at your own personal document rather than have to share one document amongst 12 people. You are free. Feel free to read along with the court, but you're not required to read this. This is the state of Tennessee versus Billy Turner, indictment number 1705881 in the criminal court for Shelby County Division 7, and these
Time for nap,
are
guys.
your final jury instructions, members of the jury. The evidence in this case has been completed. It is my duty to instruct you on the rules of law that you must follow and apply and decide in this case. The law applicable to this case is stated in these instructions. It is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each instruction in light of and in harmony with all the others. You are the exclusive judges of the facts in this case. You are also the exclusive judges of the law under the direction of the court. You must apply the law to the facts and decide in this case. You should consider all of the evidence in the light of your personal observations and experiences in life. Count 1 of the indictment charges the defendant with the offense of first-degree murder. The offense necessarily includes the lesser offenses of second-degree murder, facilitation of first-degree murder, facilitation of second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, and criminally negligent homicide.
This is an insane amount
Count
of charges.
2 of the indictment charges the defendant with
crazy.
the offense of conspiracy to commit first-degree murder. The offense necessarily includes the lesser offense of facilitation of conspiracy to commit first-degree murder. Count 3 of the indictment charges the defendant with the offense of criminal attempt first-degree murder. The offense necessarily includes the lesser offenses of facilitation of criminal attempt first-degree murder, criminal attempt second-degree murder, facilitation of criminal attempt second-degree murder, criminal attempt voluntary manslaughter, facilitation of criminal attempt voluntary manslaughter. Although there are 2 persons named in this indictment, you are to determine the guilt or innocence of only Billy Turner at this time. You are not called upon to return a verdict as to the guilt or innocence of any other person or persons. You must determine whether or not the evidence in this case convinces you beyond a reasonable doubt of the guilt of this defendant without regard to any belief you may have about the guilt or innocence of any other person or persons. There are 3 counts in this indictment. You ought to treat them as separate and distinct cases at all times. The defendant pleads not guilty to every offense charged and included in this indictment. The indictment in this case is a formal written accusation charging the defendant with a crime. It is not evidence against the defendant and does not create any inference of guilt. The law makes it the duty of the court to give in charge to the jury all the law relative to the case on trial. The duty of the jury is to consider carefully all the evidence delivered to you in the trial and, under the law given you by the court, to render your verdict with absolute impartiality. The jurors are the sole judges of the facts and of the law as it applies to the facts in the case. In reaching your verdict, you are to consider the law in connection with the facts. The court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. You shall not have any sympathy or prejudice for or against the defendant, or for or against the state of Tennessee, or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think truth and justice dictate. You may consider every fact and circumstance in the case in arriving at your verdict. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with those rulings. My rulings, these instructions, or any other remarks that I have made do not indicate any opinion about the facts of the case or what your verdict should be. Statements, arguments, and remarks to counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements are made that you believe are not supported by the evidence, you shall disregard them. The court will now explain the law applicable to the charge in count 1 of the indictment, first-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state of Tennessee must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant, or one for whom the defendant is criminally responsible, unlawfully killed Lorenzen Wright, and 2, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, and 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed in the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits the offense of second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible unlawfully killed Lorenzen Wright, and 2, that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally has been defined in these instructions. The distinction between second-degree murder and voluntary manslaughter is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter. Any person who commits the offense of voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible unlawfully killed Lorenzen Wright. And 2, that the defendant acted intentionally or knowingly. And 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions which renders the mind incapable of cool reflection. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally and knowingly have been defined in these instructions. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible killed Lorenzen Wright. And 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. The definitions for intentionally and knowingly have been provided in these instructions. Criminally negligent homicide. Any person who commits the offense of criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of Lorenzen Wright. And 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when a person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. The definitions for intentionally, knowingly, and recklessly have been provided in these instructions. The court will now explain the law applicable to the charge in count 2 of the indictment. Criminal conspiracy. Any person who conspires to commit an offense is guilty of a crime. For you to find the defendant guilty of criminal conspiracy, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained. And 2, that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder. And 3, that each party, acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder, agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder. And 4, that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy. and it must be a step toward the execution of the conspiracy. The term intent has been defined in the definition of intentionally and the first-degree murder instructions. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they be completed is abandoned by the person and by those with whom the person conspired. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. The essential elements necessary to constitute first-degree murder have been already set out and explained in count 1 of these instructions. The court will now explain the law applicable to the charge in count 3 of the indictment. Criminal attempt first-degree murder. Any person who attempts to commit first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible intended to commit first-degree murder of Lorenzen Wright, and 2, that the defendant or one for whom the defendant is criminally responsible did some act intending to complete a course of action or cause a result that would constitute first-degree murder under the circumstances as the defendant believed them to be at the time, and his actions constituted a substantial step toward the commission of first-degree murder. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit first-degree murder. The definitions for intending and intent have been provided in the definition of intentionally in the first-degree murder instructions. The essential elements necessary to constitute first-degree murder have already been set out and explained in count 1 of these instructions. Criminal attempt second-degree murder. Any person who attempts to commit second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible intended to commit the specific offense of second-degree murder of Lorenzen Wright, and 2, that the defendant or one for whom the defendant is criminally responsible did some act intending to complete a course of action or cause a result that would constitute second-degree murder under the circumstances as the defendant believed them to be at the time, and his actions constituted a substantial step toward the commission of second-degree murder. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit second-degree murder. Intending, and intent have been defined in these instructions. The essential elements necessary to constitute second-degree murder have already been set out and explained in count 1 of these instructions. Criminal attempt voluntary manslaughter. Any person who attempts to commit voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible intended to commit the specific offense of voluntary manslaughter of Lorenzen Wright, and 2, that the defendant or one for whom the defendant is criminally responsible did some act intending to complete a course of action or cause a result that would constitute voluntary manslaughter under the circumstances as the defendant believed them to be at the time, and his actions constituted a substantial step toward the commission of voluntary manslaughter. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit voluntary manslaughter. The essential elements necessary to constitute voluntary manslaughter have already been set out and explained in count 1 of these instructions. Criminal responsibility for conduct of another. A defendant is criminally responsible as a party to the offenses of first-degree murder, second-degree murder, voluntary manslaughter, conspiracy to commit first-degree murder, criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter if the offenses were committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. A defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. A defendant who is criminally responsible for an offense may be found guilty not only of that offense, but also for any other offense or offenses committed by another. If you find beyond a reasonable doubt that the other offense or offenses committed were natural and probable consequences of the original offense for which the defendant is found criminally responsible, and that the elements of the other offense or offenses that accompanied the original offense have been proven beyond a reasonable doubt. To find the defendant criminally responsible for the acts of another, it is not necessary that you find the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Before you find the defendant guilty of being criminally responsible for said offenses committed by the conduct of another, you must find that all the essential elements of said offenses have been proven by the state beyond a reasonable doubt. Facilitation of a felony. Any person who commits the offense of facilitation of a felony is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specific felony of first-degree murder, second-degree murder, voluntary manslaughter, conspiracy to commit first-degree murder, criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and 2, that the defendant furnished substantial assistance to that person in the commission of the felony, and 3, that the defendant furnished such assistance knowingly. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The definitions for knowingly and intent have been provided in these instructions. Identity. One of the issues in this case is the identification of the defendant as the person who committed the crime. The state of Tennessee has the burden of proving identity beyond a reasonable doubt. Identification testimony is an expression of belief or impression by the witness, and its value may depend upon your consideration of several factors. Some of the factors that you may consider are: 1, the witness's capacity and opportunity to observe the offender. This includes, among other things, the length of time available for observation, the distance from which the witness observed, the lighting, and whether the person who committed the crime was a prior acquaintance of the witness. 2, the degree of certainty expressed by the witness regarding the identification and the circumstances under which it was made, including whether it is the product of the witness's own recollection. 3, the occasions, if any, on which the witness failed to make an identification of the defendant or made an identification that was inconsistent with the identification at trial, and 4, the occasions, if any, on which the witness made an identification that was consistent with the identification at trial and the circumstances surrounding such identifications. Again, the state has the burden of proving every element of the crime charge, and this burden specifically includes the identity of the defendant as the person who committed the crime for which he is on trial. If, after considering the identification testimony, in light of all the proof, you have a reasonable doubt that the defendant is the person who committed the crime, you must find the defendant not guilty. The court further charges you that if you are satisfied from the whole proof in the case, beyond a reasonable doubt, that the defendant, Billy Turner, committed the crimes charged against him, and you're satisfied beyond a reasonable doubt that he's been identified as the person who committed the crime charge, then it would be your duty to convict him. On the other hand, if you're not satisfied with the identity from the proof, or you have a reasonable doubt as to whether he has been identified from the whole body of the proof in the case, then you must return a verdict of not guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. This burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Presumption of innocence, the law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. You enter upon this investigation with the presumption that the defendant is not guilty of any crime, and this presumption stands as a witness for him, unless it is rebutted and overturned by competent and creditable proof. It is therefore incumbent upon the state of Tennessee, before you can convict the defendant, to establish to your satisfaction beyond a reasonable doubt that the crime charged in the indictment has been committed, that the same was committed within the county of Shelby and the state of Tennessee before the finding of this indictment, and that the defendant committed the crime in such manner that would make him guilty under the law here defined and explained to you. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Reasonable doubt is a real doubt of the defendant's guilt based upon reason and common sense, after a careful and impartial consideration of all the evidence in the case. Proof beyond a reasonable doubt, therefore, is proof of such a convincing character that you will be willing to rely and act upon it without hesitation in the most important of your own affairs. It is not necessary that the defendant's guilt be proved beyond all possible doubt, because the absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. Direct and circumstantial evidence. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of a fact in issue without inference or presumption. Direct evidence might consist of testimony of witnesses who saw or heard what happened firsthand. If witnesses testified about what they saw or heard, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact in issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give to direct and circumstantial evidence. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. The law makes no distinction between the weight you may give to direct or circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. Impeaching a witness may be impeached by proving that the witness has made some material statements at some point before the witness testified which are different with his or her testimony on the witness stand. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, you may consider proof of any prior inconsistent statements only for the purpose of determining whether the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Further, a witness may be impeached by a careful cross-examination involving a witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard the evidence and treat it as untrue except where it is corroborated by other creditable testimony or by the facts and circumstances proved on the trial. Prior consistent statements are admissible to rehabilitate a witness or to respond to impeachment by a prior inconsistent statement. The prior consistent statements cannot be considered by the jury as substantive evidence and is to be used only in assessing the credibility of the witness. Any prior consistent statement can be used only as corroboration of the in-court testimony of the witness after impeachment by opposing counsel. You may consider proof of any prior consistent statements only for the purpose of determining whether the witness is telling the truth at trial. The contents of the prior consistent statement are not to be considered as proof in the trial. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile those conflicts, if you can, without hastily or rashly concluding that any witness has sworn falsely. The law presumes that every witness has told the truth. It is your job to decide what the facts of the case are. When you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important you think that witness testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. 1, was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? 2, did the witness seem to have a good memory? 3, how did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions? 4, has there been any evidence presented regarding the witness's intelligence, respectability, or reputation for truthfulness? 5, does the witness have any bias, prejudice, or personal interest in how the case is decided? 6, did the witness have a motive to testify truthfully or to testify untruthfully? 7, have there been any promises, threats, suggestions, or other influences that has affected how the witness testified? 8, in general, does the witness have any special reason to tell the truth or any special reason to lie? 9, all in all, how reasonable does the witness testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently. Witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about others, you may simply accept the part you think is true and ignore the rest. Accomplice. An accomplice is a person who knowingly, voluntarily, and with common intent with the principal offender unites with him or her in the commission of the crime. If a witness was an accomplice in the crime, then his or her testimony must be corroborated. Corroborated evidence is that evidence entirely independent of the accomplice's testimony, which, taken by itself, leads to the inference not only that a crime has been committed, but also that the defendant was implicated in it. This independent corroborative testimony must include some fact or circumstance that affects the defendant's identity. Corroborative evidence may be direct or entirely circumstantial, and it need not be adequate in and of itself to support a conviction. It is sufficient if the corroborative evidence fairly and legitimately tends to connect the defendant with the crime charged. It is a question for the jury to determine whether an accomplice's testimony has been sufficiently corroborated. Accomplice testimony cannot be corroborated by another accomplice's testimony. In this case, it is a question for the jury to determine whether the witness, Jimmy Martin, was an accomplice in the alleged offense of first-degree murder. If you find from the proof that the witness was an accomplice, then the defendant cannot be convicted upon the uncorroborated testimony of this witness. If you find that the witness was not an accomplice, then you would judge the weight to be given to his testimony just as you do that of the other witnesses in the case. In this case, the court charges you that the witness, Jimmy Martin, was an accomplice in the alleged offense of criminal attempt first-degree murder and conspiracy to commit first-degree murder. And before the defendant can be convicted, you must find this accomplice testimony has been sufficiently corroborated. Evidence of other acts. If from the evidence presented, you find that a witness has committed prior bad acts or been charged with other crimes, you can consider such prior acts only for the purpose of its effect, if any, on the credibility of the witness. Such evidence of other acts, if considered by you for any purpose, must not be considered for any purpose other than that specifically stated. Expert witness. During the trial, you heard the expert testimony of Tennessee Bureau of Investigation Special Agent Servinia Braswell, who was described as an expert in the field of firearms identification. You also heard the expert testimony of Dr. Marco Ross, who was described as an expert in the field of forensic pathology. You also heard the expert testimony of Sergeant Dennis Evans, Jr., who was described as an expert in the field of digital forensics and cell phone records examinations. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. In reaching their opinions, Special Agent Braswell, Dr. Ross, and Sergeant Evans testified that it took into consideration certain statements made by other persons. Because the statements were made outside the courtroom, they may be used by you only for evaluating the expert witness's opinion testimony and cannot be relied on as proof of the truth of the matters asserted in those statements. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. As with any other witness, you must decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background training, and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinion were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Defendant not testifying. The defendant has not taken the stand to testify as a witness, and this shall place, and you shall place, no significance on this fact. The defendant is presumed innocent, and the burden is on the state of Tennessee to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to testify cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Admission against interest. Evidence has been introduced in this trial of a statement or statements made by the defendant outside the trial to show an admission against interest. A confession is a statement by the defendant that he committed the crime charged. An admission against interest is a statement by the defendant which acknowledges the existence or truth of some fact necessary to be proven to establish the guilt of the defendant, or which tends to show guilt of the defendant, or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe is made and is true. You are the sole judge of what weight should be given such statement. If you decide a statement was made, you should consider it with all the other evidence in the case and determining the defendant's guilt or innocence. Prior statement of the defendant. The court charges the jury that if an oral or written statement given by the defendant has been proven in this case, you may consider it with all the other facts and circumstances proven in the case. In considering the statement, it is for the jury to determine what weight you will give the statement. You may believe any part of the statement or disbelieve any part of it, and you may believe the whole statement or disbelieve it in its entirety. Stipulations. A stipulation is an agreement. The parties have stipulated that certain matters of fact are true. They are bound by this agreement, and in your consideration of the evidence, you are to treat these facts as proved. You are to regard the stipulated testimony as if it had been given in open court by any other witness. Jury notes. Members of the jury, the court charges you that if any of you have been taking notes in this case, your notes are for your individual use only. You shall not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. Your notes cannot be shown to others, compared, or referred to in any way as authority. Your notes can be used only as an aid to your individual memory. No outside communications during your deliberations. You must not communicate with or provide any information to anyone by any means about this case outside the jury room. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, or computer, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including, but not limited to, Instagram, Snapchat, Facebook, TikTok, YouTube, Google, or Twitter, to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. Unanimous verdict. Any verdict you reach in the jury room, whether guilty or not guilty, must be unanimous. Your deliberations will be secret. You will never have to explain your verdict to anyone. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to discuss the case with one another and to deliberate with a view to reaching an agreement. If you can do so without violence to individual judgment, each of you must decide the case for yourself, but only after a full consideration of the evidence with the other members of the jury. In the course of your deliberations, do not hesitate to re-examine your personal views and change your opinion if convinced it is erroneous. However, do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Selecting foreperson. And ladies and gentlemen, I'm going to read the whole charge for you today. And we'll start with jury arguments on Monday morning at 10. So I'm going to read the whole charge. Normally, I would have stopped reading the charge here, would allow the lawyers to present their closing arguments, but we will read the whole charge today. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have returned a verdict, you will return with your decision to this courtroom, and your foreperson will deliver the appropriate verdict form to the court. Multiple counts. The defendant has been charged with several crimes. The crime charged in each count of the indictment is a separate and distinct offense. The number of charges is no evidence of guilt, and this should not influence your decision in any way. It is your duty to consider the evidence that relates to each charge and to return a separate verdict for each count of the indictment. Your decision on one charge, whether it is guilty or not guilty, should not influence your decision on any of the other charges. The defendant may be found guilty or not guilty of all of or all of the offenses charged. Your finding as to each crime charge must be stated in your verdict. If you find the defendant guilty on all charge from the evidence beyond a reasonable doubt, you should convict on all. If you find from the evidence beyond a reasonable doubt one or more charges guilty and have a reasonable doubt as to the guilt of the other counts or counts, you should convict on the counts you are satisfied by reasonable doubt as to the guilt of and acquit on the others. If you have a reasonable doubt as to the guilt on all, you should acquit on all. Deliberation order of consideration. In reaching your verdict, you shall first consider the offense of first-degree murder as charged in count 1 of the indictment. If you unanimously find the defendant guilty of first-degree murder or of being criminally responsible for first-degree murder beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of first-degree murder or of being criminally responsible for first-degree murder, or if you unanimously have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within the indictment. You shall not proceed to consider any lesser included offense unless you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in the indictment, you shall return a verdict of not guilty and proceed to the next count. The charge offense in count 1 of the indictment is first-degree murder. The lesser included offenses within the indictment are as follows: second-degree murder, facilitation of first-degree murder, facilitation of second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, criminally negligent homicide. When you consider your verdict in the indictment, you will first inquire whether the defendant is guilty of first-degree murder or of being criminally responsible for first-degree murder as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of first-degree murder as charged in count 1 of the indictment. If you unanimously find the defendant not guilty of first-degree murder or of being criminally responsible for first-degree murder as charged in the indictment, or if you unanimously have a reasonable doubt of the guilt of the defendant of this offense, your verdict must be not guilty as to this offense, and then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offenses as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in count 1 of the indictment beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count 1 of the indictment. You will insert in said blank space the lesser included offense. If you find the defendant guilty, you can convict him of only one of the above named offenses charged and included in the indictment. If upon all the proof, you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict should be, we the jury find the defendant not guilty of count 1. You write your verdict as count 1 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. After you reach a verdict in count 1 of the indictment, you will next inquire to your verdict in count 2. You will use the same rules in this count as you were instructed to use in the previous count. The charge offense in the indictment is conspiracy to commit first-degree murder. The lesser included offense within the indictment is facilitation of conspiracy to commit first-degree murder. When you consider your verdict in the indictment, you first inquire whether the defendant is guilty of conspiracy to commit first-degree murder or of being criminally responsible for conspiracy to commit first-degree murder, as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of conspiracy to commit first-degree murder as charged in count 2 of the indictment. If you unanimously find the defendant not guilty of conspiracy to commit first-degree murder or of being criminally responsible for conspiracy to commit first-degree murder as charged in the indictment, or if you unanimously have a reasonable doubt of the guilt of the defendant of this offense, your verdict must be not guilty as to this offense, and then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offenses as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in the indictment, beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of facilitation of conspiracy to commit first-degree murder as included in count 2 of the indictment. If you find the defendant guilty, you can convict him of only one of the above named offenses charged and included in the indictment. If upon all the proof, you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment, under the law defined and explained to you, it is your duty to acquit him, and your verdict should be, we, the jury, find the defendant not guilty of count 2. You write your verdict as count 2 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. After you reach a verdict in count 2 of the indictment, next inquires to your verdict in count 3. You use the same rules in this count as you were instructed to use in the previous count. The charge offense in the indictment is criminal attempt, first-degree murder. The lesser included offenses within the indictment are as follows: facilitation of criminal attempt first-degree murder, criminal attempt second-degree murder, facilitation of criminal attempt second-degree murder, criminal attempt voluntary manslaughter, facilitation of criminal attempt voluntary manslaughter. When you consider your verdict in count 3 of the indictment, you will first inquire whether the defendant is guilty of criminal attempt first-degree murder or of being criminally responsible for criminal attempt first-degree murder as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of criminal attempt first-degree murder as charged in count 3 of the indictment. If you unanimously find the defendant not guilty of criminal attempt first-degree murder or of being criminally responsible for criminal attempt first-degree murder as charged in the indictment, or if you unanimously have a reasonable doubt of the guilt of the defendant of this offense, your verdict must be not guilty as to this offense, and then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offenses as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in the indictment, beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count 3 of the indictment. You'll insert in said blank space the lesser included offense. If you find the defendant guilty, you can convict him of only one of the above named offenses charged and included in the indictment. If upon all the proof you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment, under the law defined and explained to you, it is your duty to acquit him, and your verdict should be, we the jury find the defendant not guilty of count 3. You write your verdict as to count 3 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. Ladies, you know, I've talked to you about the jacket and how you go about recording that verdict on Monday. It is 2:42, and as I told you before the break, you would probably hear 3 arguments. And I can't put time limits on lawyers' arguments. One day this course will define what they mean by what is adequate but not excessive. So those 3 arguments might take an hour and a half, they might take 3 hours, they might take 4 hours, and then you have to deliberate on this case. And one of your members, at least I'm told there may be more than one, indicated to the judge, we really don't want to work tomorrow, can we come back first thing on Monday morning? There are, if my math is correct, don't hold me to that, I think there are 19 possible verdicts you can reach on this case. 19 possible verdicts, including 3 verdicts of guilty as charged, 3 verdicts of not guilty of anything, and some 13 verdicts that could be reached on included offenses. Now, I'll talk to you about that on Monday also. It's not a menu. It's not a multiple choice test. Once you start deliberating on the case, you don't go back to the jury room and say, which one of these sounds better? Or I have multiple choices and which one of these do I think fits? You cannot consider any lesser offenses on this case unless you unanimously made a decision that Mr. Turner is not guilty. For instance, in count 1, you deliberate on whether or not he's guilty of first-degree murder or criminally being responsible for that offense. If you find unanimously beyond a reasonable doubt that he's guilty, you record that verdict. If you unanimously find he's not guilty of first-degree murder, or unanimously have a reasonable doubt, then and only then can you consider the lesser included offenses, and you start with second-degree murder. But you cannot consider any lesser charges in any counts of this indictment unless you found him not guilty of the charged offense, or unanimously have a reasonable doubt as to whether or not the state is in fact proven that he's guilty. Does everyone understand that?
Yes.
Thank you for your patience. We'll find something for you to do tomorrow, movies, or maybe the zoo, or I don't know, maybe bowling or some other activity. If there's somebody, I know some folks says, Judge, I don't want to work on Sunday, it's a religious day. If we can find somewhere in a hotel in your hospitality suite, some services, church services that you may be interested in watching, they will put those services on at a live streaming, because a lot of churches still are not holding services necessarily in person. A lot is still holding live streaming services. So we find something for you to do. Enjoy your day off. It's supposed to be a little bit warmer tomorrow, a little bit more sunshine. And we'll see you back in court on Monday morning at 10 o'clock. I will qualify the next grand juries for the March term, 24 folks just like you that will be sitting and meeting on every Tuesday and every Thursday for the next 2 months. And we'll start hearing arguments on the case at 10. You cannot discuss the case with anyone else. You cannot discuss the case amongst yourselves. You've heard all the law. You heard all of the evidence that you will receive in this case, but you cannot start discussing the case until the lawyers have completed their arguments and have discharged two alternates, and then and only then can you start discussing the case. So when you're out and about over the weekend, over the next, oh my goodness, 36 hours or so, don't be in little circles or little bitty private meetings and say, hey, what do you think? What do you think? And when we go back to court on Monday, we're going to already have this case decided. You cannot discuss this case at all until the alternates have been excused and you've been discharged with this jacket and all the trial exhibits to start properly considering the case. Let me know how the deputies are treating you. Let me know how the food is, how the accommodations are. And if you have any special requests, let the deputies know, because we're going to hold you as guests of Shelby County over a period of time where you will not be in court for about 36 hours or so. And that's asking a lot. But as I told you on Monday, if any one person says, Judge Coffey, Sunday is not a good idea to hold court, we stop and we will not hold court on Sunday. And I give deference to folks in their religions, because I do not trample on a person's religious beliefs. That would be unconstitutional for me to do that. Thank you for your patience. Thank you for your patience this whole week. We'll see you on Monday, and it's probably sometime early Monday afternoon you will be deliberating on this case. You can follow Deputy Smith. Have a great weekend. And for the regular conversation with those last three jurors, they wanted to know how my finger was doing. So I gave them a short answer that I need a housekeeper. Long answer is it'll take 3 or 4 months for it to fix itself. Anything else we need to address before we adjourn for the weekend?
Must have tore his finger bad.
Yes, sir.
One of the exhibits introduced in the trial was a photo identification by Jimmy Martin of Billy Turner. Don't know what number it was.
Yes,
By
sir.
the time it was introduced, it was 2 pieces of paper, the actual photo spread that's circled and this advice of rights. The witness looked at both of those things, and I think it should have been a 2-page exhibit, but this advice of rights keeps on appearing on the table without the exhibits.
Yes, sir. That came in through Mr. Martin. Madam Clerk, that should be exhibit number 76.
Yeah, he'll definitely get a conspiracy. I think he gets the first degree, though, planning. I think he did it. But they give so many options, I think the jury may just give him other
76,
charges.
and, I'm sorry, Jimmy Martin, okay. That was the advice rights of the witness viewing a photographic lineup. Okay. Exhibit number 76, the photographic lineup. And I think when it was handed to me, I think it may have been handed just the photographic spread itself and not the advice, and that's how I got separated. But I will append to exhibit 76, the advice of right, as well as the photographic display will staple it together so it doesn't get separated again, and it would be appended as a collected exhibit rather than just the photo lineup, because what was handed to me was just that one piece of paper that it got separated. That part was not marked. In fact, it would probably, not probably, it would have marked them separately, because I hate marking different items with one number,
Perfect timing,
because
toxic. We're
sometimes
done,
they get
so.
separated. And it may get confusing with the appellate courts if they come up as a collected exhibit, but I'm appending the advice to witness viewing photographic display. Mr. Martin identified that he looked at before he identified allegedly Mr. Turner, and that has the sticker 76 on it, and I'm putting the advice in front of that so that it would in fact show it is exhibit 76. Anything else?
Okay, Rory, have a nice night.
Yes, sir. Doesn't need to be on the record. No? Okay. Let me call the court into I'm sorry, you may adjourn court. Stop that. Court stand adjourned to 9 o'clock Monday morning, March 21st, 2022. Will impanel the grand jury for the March term 2022 for Shelby County, Tennessee at 9, and we'll start jury arguments at 10 o'clock. Court stand adjourned to Monday morning.
All right.
Well, that's it. Shush. So that's it, guys. We're all done. Monday morning, starting at 11, the jury starts deliberating. 11 o'clock Eastern Standard Time, so... I don't know if we'll get manslaughter. I think he gets convicted of first degree planning, intentional homicide. I think they convict him on everything. I feel... I mean, that Jimmy testifying was devastating, and they didn't have much they could... Excuse me. Get out now. What? Yeah, so that's it, guys. I think that's going to be it, and we'll see what happens. I might just leave it... we might do Dr. Husel starting Monday, unless they come back with a verdict right away, guys. I don't know what else is running coming up, but we can go back to the boredom of that. I wish there was a better case to run, but I don't think there is. So, well, Sherra got off easy because Sherra took a plea. Billy refused to take a plea. I bet Billy would have gotten a similar offer had he wanted to plea. But he didn't. He wanted to go to trial. So I have the feeling he gets convicted of everything. I mean, I'd like to think, but we'll have to hear about the closings. Remember, we're not done yet. The closings still have to happen. Well, the pregnant cousin's testimony wasn't bad. It's just, it wasn't, yeah, she hung out with him, but earlier in the night. So, that's really it, guys. Yeah, so it's, I don't know where you are, but it's a rainy and cold Saturday here for me, so, I'm going to try to work on some other stuff around the house, and that'll be it for me. Billy will be the fall guy? I think so. Well, that's a problem when you're, it's the problem when you're the last man standing. Everybody comes after you. So, yeah. So, well, I'm about to, Sean runs me off. Thanks, guys. 70 and sunny. Lucky, lucky, lucky. It's like, what is it here? It is... Oh, there's no way it's 59. I have my window open and it's cold. It's got to be 50-something. Yeah, it's like 45 here, so... It's cold. We're done. Yeah, I'll see you guys Monday morning, and we'll start up Dr. Husel. And, well, actually, you know what? We'll wait till 11 o'clock on Monday morning. We'll start the closing arguments. We'll let the closing arguments go. And then we will begin Dr. Husel and restart that until something new pops up. So, you guys have a great weekend. See you Monday morning, 11 a.m. Eastern Standard Time.